All right, who's here on Roland Hernandez?
Hey, Judge, they just brought him out.
Okay. You ready to approach?
Yes, ma'am.
All right. All right, so on each of these, you requested a bond?
I filed a motion, I guess, setting bond, but I think I confer with Megan that we are here on a discovery setting. I think we're
Okay.
still waiting on additional discovery.
All right.
All right, courtroom junkies, we are live and gavel to gavel with Judge Boyd. She's moving through this docket like a seasoned captain steering a ship. But don't let the calm vibe fool you. Underneath that cool exterior is a legal mind that sees everything. We've got a packed calendar today, from discovery disputes to high-stakes bench trials. The question is, who's ready for the heat and who's about to get burned? Let's roll.
So there are no bond issues to be heard?
Yeah, I'm fine. Okay, I don't think so, Judge. I think we're just the discovery issue.
Okay. All right, so what's the discovery issue?
Judge, so we have reached out to the arresting agency to provide the discovery. They had responded to our office saying that they submitted it through our e-discovery and question system. When I checked in preparation for the setting, it had not yet been, I guess, I don't know if it's like lost in the ether or what. So I did reach out to the arresting agency again, saying that they need to provide us a hard copy of it. That way I can be in receipt of it to turn it over to Mr. Maurer.
All right, and when do you think you may have that?
I would ask for 2 weeks for that, please.
All right, Ms. Ferguson, I need a 2-week reset on Hernandez, please. July 8th. All right, is there anything else?
Let me confer. That's it, Judge. I'm going to confer with them. Really quick.
Okay. Mario Hernandez, if you'll come forward, please.
Also,
Norm, I need a date for late July, please.
Hold up. Did you catch that? Judge Boyd just put a hard stop on the bond talk and zeroed in on the discovery issue. For those of you new to the legal game, discovery is the pre-trial phase where both sides have to share their evidence. If the defense doesn't have it, they can't prepare. Watch how she handles this. She's not just taking their word for it, she's setting a hard deadline. That's a judge who controls the room. But is the prosecution dragging its feet? Drop a comment if you think that's a stalling tactic.
Good morning. So your attorney is actually still in the legislative session. So we're going to recall you for July 28th, okay?
okay.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Welcome.
All right, thank you.
Just
All right, William Barnes. Oh, so you all are ready for trial?
I'm ready, Judge. The only problem I have is that I spoke to the prosecutor and they expected to go on to the 26th. And I have a vacation letter in that I'm leaving on the 26th in the morning.
Where
Where am I going? I'm going to Port A. We're going fishing. We booked a charter and stuff like that.
state?
Right. Yeah.
No problem. So why do you guys think this case will go towards the 26th?
We have 5 witnesses, Your Honor, and even if we pick the jury today and do the trial tomorrow, I would imagine that getting through that and then the charge conference and doing closings and having a jury deliberate would probably at least carry into Thursday at the latest, I would think.
We have one witness, Judge.
So you all want a bench trial?
It's not up to me, Judge.
Well, if you want to ask your client about a bench trial, I'll let you all confer.
Okay, thank
All
you.
right, thank you. All right, are you all ready on Saldana? All right, so before we go on the record, I will give both parties a chance to address final issues, and then I'll make my ruling.
Oh, I don't have anything more to say on that.
All right. Well, we'll see if maybe the state has something else they want to say with regards to it. So the court is calling 2025 CR 003338 State versus Carlos Vasquez Saldana. Can I have parties announce?
Megan Galloway for the state.
Roberto Vargas for the defendant, ready to proceed, Your Honor.
Okay, rewind. Did we just hear that right? The defense attorney says they're waiting on documents, but Judge Boyd is already 3 steps ahead, checking for language barriers and consent issues. This is where courtroom drama gets real. When you have a non-English speaking defendant in handcuffs, the question of voluntary consent isn't just legal jargon, it's a constitutional landmine. The tension here is palpable. Is the officer's search gonna hold up, or is this about to get suppressed?
And are you Carlos Vasquez Saldana? You need to respond yes or no.
Yes.
All right. And we have an interpreter here. If you could raise your right hand for me. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
My name is Catalina Delgado, spelled Delgado, license number 2222.
All right. So we were here for a bench trial and there was a motion to suppress presented during the bench trial as well. So the court recalls the evidence as follows. The defendant was pulled over for an expired registration. And after he was pulled over for an expired registration, he was asked to step out of the vehicle. He was placed in handcuffs. And once he was placed in handcuffs, then there was a question of his consenting to search. So the officer asked to search and he gave consent when he was in handcuffs. Is that correct?
No, Your Honor, it's a language barrier, so they call the second officer.
No, I mean, I know that's in between where they call another officer to come out to interpret, but my memory is that you have the expired registration, then he's placed into handcuffs, and then he's asked to give consent to search.
That's correct.
Well, I just want to be more specific on the record, Your
Okay,
Honor.
go for it.
The arresting officer realized he didn't speak Spanish, so he called the second officer. At which time they waited for the second officer to show up, and the second officer showed up. That's when he started to interview the guy. And he had asked him if he can search the vehicle in Spanish.
All right. So my understanding is from reviewing the video and listening to the testimony, it wasn't as though that there was an hour time elapsed between the officer requesting someone who spoke Spanish or an officer who spoke Spanish to come on the scene. My understanding is there wasn't a unreasonable amount of time between the English speaking officer and the Spanish speaking officer arriving. Is that correct?
I don't know how much time went by.
It was the amount of time that elapsed between when the first officer pulled the defendant out of the vehicle to when the second Spanish speaking officer arrived was less than 5 minutes. And I think that would be supported by the evidence that was admitted in the trial.
All right. So what the court can say in reviewing the video, the consent to, the arrival of the Spanish speaking officer, the court is going to find that there wasn't an unreasonable amount of time that.
Let's take a temperature check. Judge Boyd is deep in the weeds of a motion to suppress, and she's asking the million-dollar question. Is consent valid when you're in cuffs? That's the holy grail of Fourth Amendment law right there. The defense is arguing duress, which is a fancy way of saying my client was scared out of his mind. The prosecution is leaning on officer safety. I'm putting this to you, the jury of the internet. Would you feel free to say no to a search if you were handcuffed in front of a police car Type F for free or C for coerced in the comment.
The Spanish-speaking officer arrived after police had first contact with your client. So does anyone want to again address the issue of his giving consent to search while he was in handcuffs? Because I believe that's the crux of your argument, that the consent to search wasn't voluntary.
Yes, Your Honor. Just when the second officer showed up, my client was already in handcuffs in front of the police car. At this time, he's in handcuffs and no one has told him what he's being charged with or why he's being detained. When the second officer showed up, he speaks Spanish. He should initially told him what he was charged with before he started the conversation. He should have also read him his rights in Spanish. The second officer speaks Spanish. There's no reason why they needed to call the third officer so he can read him his rights in Spanish. But that's the heart of my argument, is that the second officer speaks Spanish. He asked him questions, didn't tell the guy what he was being charged with. He just started asking him questions. And my client was nervous. It's reasonable for a person late at night being taken out of your vehicle in handcuffs and no one's telling you what you're being charged with, and they're bringing the second officer who speaks Spanish. He could at least have the courtesy to tell him, hey, you're being charged with this, and then ask him questions, or you're being charged with this. I'm gonna read you your rights, and then I'm gonna ask you questions. After I read you your Miranda rights, do you consent to a search?
But do you need to give someone their Miranda rights in order to obtain a consent to search?
Well, in this case, we would, because the guy's in handcuffs. I mean, the guy's just standing out there like anybody. You don't need to read him his rights, but this guy was under the impression that he's under arrest because he's handcuffed and no one tells him what he's charged with. So if you're under the impression you're under arrest because you're in handcuffs, I think you should read him his rights before you start speaking to the person.
But didn't they say that, or the video shows that he's being detained and the officer testified that he's being detained? And the reason why he has him in handcuffs, the officer testified that when he pulled him over, that he appeared to be making furtive movements in the vehicle.
He said he saw my client, see my client's as tall as me, while driving, reaching into the glove compartment and playing with it with tinted windows. I'm as tall as this guy, and I tried to check my glove compartment the other day. It's impossible without weaving. The windows were tinted, so it's a question of credibility of the officer. But either way, no one told him why he was in handcuffs. Officer told us in English why he did it, but he never told my client why he put him in handcuffs. And that's the most important thing. If you're gonna put someone in handcuffs, you know, you tell them how you're doing it.
All right. And then my understanding from the testimony reviewing the video, he was only asked one time whether or not he would consent to the search of the vehicle.
Yes.
Okay. All right, State.
Judge, my response is just that at the time that the defendant was placed in handcuffs by Officer Johnston, it was a legal detention. At that point, the defendant had failed to identify himself. And so that, in addition to the furtive movements that were observed and testified to by the officer, gave him the ability to place the defendant in handcuffs for officer safety, which was also testified to. At the time that the second officer, Officer Garza, was communicating with the defendant, although he was in handcuffs, no arrestable offense had occurred at that time. And I think that's important in the court's consideration of whether a custodial interrogation was taking place. In the case that I submitted to the court the last time that we were here, it states that no Miranda is required to obtain consent to search. And regarding the handcuffs or being in custody, that's just one factor for the court to consider, in addition to the other factors in the cases that I provided, such as the law enforcement presence, the place of the stop, and all the other factors that that are obtained in the case law. And so we would ask you to deny their motion.
All right, defense, I'll give you final argument if you have any more information to add.
Other than the fact, Your Honor, he was put in cuffs because the officer believed he was in danger because he allegedly thought he saw my client reach into the glove department. Based on his experience of less than 2 years, There was no traffic violations. My client wasn't under the influence of drugs or alcohol. Right off the bat, there was a communication problem. And it's not, he wasn't trying to deny his ID. He didn't understand what my client was saying. But the simple fact is, if you put someone in handcuffs, under my case law, what a reasonable man would think, you got me under handcuffs and behind in front of your police car and you yet to tell me anything and you wait for another officer, I'm going to assume that I'm under arrest. And at that point, his Miranda rights should be kicked in so he can decide if he's going to answer questions or not. At least he knows his legal rights. As far as him only being asked once, well, you don't have to be asked twice. If you're scared, you'll answer right off the bat. But under the reasonable person.
Boom, there it is. The judge just dropped the hammer and denied the motion to suppress. That means the evidence stays in, and now we're shifting gears from a legal argument to a full-blown guilt-innocence trial. Watch how her tone changes. She goes from legal philosopher to fact-finder in a heartbeat. This is the pivot point. The defense just lost a major battle, but the war is far from over. Can they prove the drugs weren't his, or is this a done deal?
Point. If I was in handcuffs in the back, I'm thinking I'm going to get arrested. So at that point, second officer shows up. Got rookie officer should have went and told the guy, hey, this is what he's being stopped for. Let him know, read him his Miranda rights. Instead, he started having a conversation like they're friends. Like, you're not my friend if you have me in handcuffs.
Mm-hmm. But doesn't the conversation, as you said, as though they're friends, doesn't that speak to voluntariness, that it wasn't
No.
That it wasn't an intense situation, at least from the officer's standpoint, and from your client's standpoint, it wasn't a contentious interaction.
I mean, from the officer standpoint, he's talking to you as a friend, but as far as the one in handcuffs, hey, you're afraid, you're going to, for all you know, you're being arrested. You don't know what you're being arrested for because no one has told you up to this point.
So are you saying that if there were no handcuffs on him and he consented to a search of the vehicle, then it would be legal?
Absolutely, Anna, because you feel more comfortable if you're in handcuffs. But you're handcuffed with your hands behind your back with the lights on and the second officer shows up. I mean, any reasonable person would think he's going to get arrested.
But with it, and let's talk a little bit about the language barrier. So the officer who communicated to him about the consent to search, that officer was a Spanish-speaking officer, and that officer spoke to him in Spanish?
Yes, Your Honor.
And that officer explained to him the consent to search form in Spanish?
No.
Right, what do you mean, no?
He just asked him, "Can we search your car?" And he said, yes.
All right, so he understood that it was a consent to search form, and he agreed to the search in Spanish.
He didn't sign no consent. It was all verbal, Spanish translation. But like I said, if you're under arrest, you don't know your rights, you're nervous, you're handcuffed, you're going to cooperate with the officer under duress.
All right. This is what the court is going to decide. The court, based upon the evidence that was presented to the court, and the court has considered arguments of both sides, the court is going to deny the motion to suppress. Now, with regards to the evidence that was presented, counsel, you want to make closing arguments?
Just let me get my
Yes.
points. Whenever you're ready, Your Honor.
Yes, I'm ready.
Your Honor, the issue before the court at this point has the state proving the case beyond a reasonable doubt. I submit they have not.
Oh, if you'll slow down a little bit, because she's translating it then.
Regarding to the facts of the case, the officer saw my car traveling in a high crime area late at night. No, did not witness any traffic violation, just ran the plates and found that there was a expired sticker. So he initiated the stop. As the officer followed my client, he states he saw my client reaching into the glove department. The officer states that my client passed up several public parking areas well there where he could have parked. But instead he pulled over on the side of the street. But at no time did he try to evade. He was driving slow enough for the officer to keep pace with him. Now, when the officer stated that he saw my client reaching into the glove department while he was driving, like back windows were tinted, and it was his opinion that the light on his car showed shadows where he was extending into his glove department. But the video speaks for itself, John. When you look at the video, you can't see any shadows, people extending back and forth.
Mhm.
As a result of that, he believed he was in danger based on his less than 2 years experience as an officer, and approached the driver's side of my client and pulled him out and handcuffed him. But as he watched the video up to that point, my client had his hands on the wheels and was cooperative with the person. Remember, there was a language barrier. As a result of the language, as a result that he saw him reach into the alleged blood department, he pulled my client out, put him in handcuffs, took him to the front of his police car, and at which time he radioed for a second officer who spoke Spanish to come and help him. When the second officer arrived, no time did him or my client, and no time did this officer or the other officer tell him why he was being stopped and what he was being charged with. The officer just started to ask him questions. At this point, he asked my client if because during that conversation, my client told him that it wasn't his car, it was his boss's car, that he was borrowing it. When asked to search the vehicle, my client consented. This is still prior to any Miranda rights. During the search, the officer searched the front, the middle console, and underneath some stuff he saw some paraphernalia involving to use to smoke. And based on his experience, he thought it was a drug paraphernalia. So based on that, he continued the search. He searched the front seat, he searched the glove compartment, he searched the back seat. Nothing until we reached up top where the glasses are and he found some stuff. If it's testimony to be truthful, we hold the officer's testimony to be truthful, then the only movement that he saw my client do during the drive was reach for the glove department, never did he reach for where the glasses should be. Well, all officers told him that he was stated that he did not think he was not under influence of any drugs or alcohol at the time. And the second officer spoke Spanish, which time when they found the drugs, should have read him his rights. Instead, they called in the third officer to read him his rights. Most people that borrow someone's car, they don't do an inventory check of the vehicle before they drive it, so they don't know what's in the car. Unfortunately, things like this happen. Based on the circumstances, Your Honor, I mean, if he's borrowing this car and the officer's only testimony and saw him reaching the glove department and never looked up there, and if my client would have had drugs, we would probably told him he had drugs because he told him he can search the car. He was being honest with the guy. He wasn't aware of these drugs. Based on the circumstances, perhaps it can be my client's drugs, but that's not good enough to find him guilty. You can suspect it is my client's drugs because he is the only one in the car, but that's not good enough to find him guilty. My client is possibly guilty of possession of drugs, but that's not good enough to find him guilty. My client is probably guilty of possession of drugs, Your Honor, but that's still not good enough to find him guilty, Your Honor. My client is likely guilty of possession of drugs. Your Honor, that still doesn't reach the burden that the state has to prove that he's guilty. My client is highly likely guilty of possession of drugs, Your Honor. That still doesn't meet the standard for the state to meet to find my client guilty. And based on the testimony of the officers that we heard, Your Honor, The state has failed to prove guilt beyond a reasonable doubt and asks that you find Carlos not guilty.
All right, State,
Your Honor, we have proved the elements of the indictment beyond a reasonable doubt. Beginning with the honor about January 2nd of 2025, Officer Johnston did testify that he was on patrol in uniform in a marked patrol vehicle on that date when he observed the motor vehicle that the defendant, Carlos Vasquez Saldana, was operating on a public roadway. Officer Johnston testified that he did run the license plate belonging to the vehicle and the registration came back as expired. And that is the reason for the traffic stop that he initiated. When he initiates his red and blue overhead lights, I think it is of significance that the defendant did not immediately pull over. And the state's exhibit, you can see that the defendant passes up two well-lit areas that were parking lots that he could have pulled into. And while it does not rise to the level of another offense, I think that lends to the officer's credibility of the furtive movements that he observed the defendant making during that time and also to a consciousness of guilt. Now moving on, when Officer Johnston does initiate contact with the defendant, he does observe him in the driver's seat. There's nobody else in the vehicle. It did come out during testimony that the registered owner is not the defendant. However, he was in exclusive possession of the vehicle. I think that important facts that link the defendant to the car is you see in the state's exhibit that he's wearing a red hoodie that has a construction company. When the officer does search his person, he finds nails in the pocket. There's multiple tools in the car, linking the defendant to the car. Officer Garza does make the scene, and he is the second officer on scene. He's a Spanish-speaking officer that obtains the verbal consent to search. At that time, Officer Johnston goes to the car. He finds a pipe that is consistent with smoking narcotics. At that point, he takes it over, shows Officer Garza, and then he goes back and continues to search the car. When he's searching the car, the methamphetamine does fall down from the sunglasses case that is seized, sent off to the lab. And the forensic scientist did testify that it was 0.253 grams of methamphetamine. Now regarding the affirmative link, or what affirmatively links the possession of the narcotics of the methamphetamine to the defendant, is that broken piece of the pipe that Officer Garza testified that he seized from the defendant's pocket. And so that goes to the intentionally and knowing of the indictment. And so we have proved this case beyond a reasonable doubt, and we ask that you find the defendant guilty.
all right. The court will find the defendant guilty. If you could pull a trial court certification of defendant's rights to appeal, please. And then we'll move into sentencing.
Okay.
All right, the court having found the defendant guilty, State, what are you requesting for punishment?
Judge, the defendant does not have any criminal history or any prior felony convictions. And so I think under 42A.551, he is mandatory community supervision. So we're just asking for 2 years probated for 2 years.
We're asking for 1 year probation, Your Honor.
The minimum is 2. So
We're in agreement there.
all right, sure. So the court will sentence you to 2 years in the state jail facility, suspended and then probated for 2 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits 1 time per month for 3 months, a TAP evaluation in custody, follow recommendations. And your client is not a citizen, correct?
Oh, yeah.
And there's to be no illegal re-entry into the United States. Probation, is there anything else? All right, Mr. Saldana, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right. And counsel, were you ever able to explain this document to your client in in Spanish?
Yes, I use the translator, so there's no mistake, Your Honor.
Great, thank you. All right, you do have a limited right to appeal. Well, not a limited right to appeal. You have a right to appeal because this was a bench trial. And also you have a right to appeal the court's rulings, any of the court's rulings. Do you understand?
Yes.
All right, because this is a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Okay.
All right, good luck to you. Thank you.
May I get excused?
Yes.
Thank you.
Gilbert Salinas?
Yes, Your Honor. May I approach?
And just like that, Chapter 1 of this courtroom saga wraps up. Judge Boyd showed us why she's got that reputation. She's patient, sharp, and unafraid to ask the tough questions. From a hard-fought suppression hearing to a swift verdict, she's laid the foundation for what's going to be a wild rest of the session. Let's recap. She denied the motion, found the defendant guilty, and now we're moving on to the chaos of the general docket. Stick around, because if you thought that was intense, the next chapter is going to be pure courtroom gold.
All right, where's the client?
He's in your front now.
Come forward.
Oh, good.
All right, so Mr. Salinas, today is your plea deadline date. So are you requesting a jury trial?
No, Your Honor. What I'm requesting is a 2-week, no more than 3-week reset for the plea deadline because we're trying to get with the apartment complex to find restitution amounts, if any, so they can properly evaluate the offer that the DA has made.
All right, Norma. Recall this for the week of July 7th. There will be no further extensions.
I understand, Judge, and I greatly appreciate that.
All right. All right, July 8th. And you'll need to be here in person.
Yes, Judge.
All right, once you sign the reset form, you excuse.
Thank you.
Thank you. Quentin Dixon. Hi.
Judge, I apologize for not being here when you called me. I had to go get a tape measure.
Oh,
He's gonna need you close.
oh, most definitely. So you all are going to trial?
Not yet, Judge. You asked me to come back in today,
You're
but
going to get that information, but this is going to be trial?
I'm hoping not. But
Okay.
I've got to get Dr. Murphy's report first. I talked to her this morning. The package that she needed from Mr. Dixon is en route to her.
Okay,
So she's thinking 3 weeks.
all right.
Now, if she's got to do an in-person visit with him, it'll be longer. But if she does it by Zoom, it'll be 3 weeks.
All right, so. All right, the week of July 14th, that's the final date I'm giving you all.
Your Honor, if you'll give me just a moment.
Sure.
Judge, I'm out of state from the 11th to the 20th with the court.
I can bring you back the 7th or the 8th
Of August,
July.
of July. I don't know if that's going to be enough time for her to do
When are you going to be back?
the 20th of July. It's a Sunday, I think.
All right, Norma, set this for the 21st.
You're most kind, Your Honor. Thank you so
Sure.
much.
There'll be no further extensions of the plea deadline date.
Thank you, Your Honor.
Is there anything else?
No, Judge, I think that will cover it. And if I get any indication from Dr. Murphy, she's not going to make the deadline, I'll let the court know.
All right, thank you.
Thank you, Your Honor.
Is there anything else?
No, not with respect to
Oh,
Mr.
did you say
Dixon.
you need to measure him or
I
something?
do, I'll do that in the back.
Okay,
And have Mr. Flores also here today, Judge.
all right. Deputy, are you okay with me doing his other client very quickly? All right. Flores.
Judge, on Mr. Flores, I've got some discovery issues
Mhm.
and I got appointed last night
To the other case.
to another case.
And that's I think that's the state jail felonies.
Yes, Your Honor, it is. It's an unauthorized use.
All right, what are the discovery issues?
Yes, Judge, on the manufacturing delivery case,
Mhm.
there are 11 large files. I had made a request on May the 10th for the large files via Veripic, but I never got it. I requested it last night And I talked to Andrew about it this morning, and Andrew's got a advocate working on copying what they can for me right now.
Okay, I think you're probably gonna need a drive or something if it's too big.
I think so, Judge. I got 4 drives out in different cases right now, so I've got to get another drive.
All right.
And I told him I'd be back by Friday with the drive,
All right, so I'm gonna recall this for discovery for July 21st.
July 20th. Thank you, Judge.
You're welcome. All right, do you have any questions?
Is there a way I could get a bond?
You'll need to speak to your attorney, and your attorney can file whatever motions, and the court will hear it. All right,
Judge, I'll follow a motion.
all right, thank you.
Thank you, Your Honor.
Flores.
Natasha Manning. Natasha Manning,
Present on her, Judge.
yes.
This is the individual who has her young child with her.
I've explained to her in the future, she needs to make arrangements. It's essentially her first court date after her matter had been indicted. So I conferred with the state on this one, Judge. So due to the nature of the charge, there is a lot of discovery. It's quite voluminous. There's over 30 videos as well as a number of reports from ACS. At this time, I don't see an autopsy report done as to the subject matter of this case. So I'm requesting just a 2 to 3 week reset in order to properly vet all the discovery, make sure nothing's missing, Judge.
Norma, I need 3 weeks, please.
That works for me.
All right, so just one moment. Who's the prosecutor on this? All right, Norma Manning, that's gonna be, of course, you know, recall for the 17th. Richard Ibanez?
Present on his case also.
Yes.
So with this one, Judge, with regard to discovery, we believe that there's some outstanding portions at this time from Leon Valley Police Department. I know it's a smaller municipality within San Antonio, so their system isn't as automated in terms of uploading videos. In referencing the discovery, there's one PDF file with some reports, as well as one body worn cam video. There, in our estimation, maybe believe missing photos, missing videos when he was taken into custody with regard to the warrants, and a report thereafter to see if he made any statements or not. So all that stuff is outstanding.
Say about what you think is missing.
I did, Your Honor. Yes, I communicated that over to them. They said that they were going to reach out to Leon Valley as well as U-Haul to see if they can get some additional pieces of information, evidence. At this time, we believe it's lacking, that they can't necessarily prove their case. So I know that they were on board as well with having a little bit of time. If perhaps the court saw fit to reset it to July 17th, 3 weeks, in order to afford the state some time to do that, would appreciate it, Your Honor. Set it on the same date if you could.
July 7th.
Okay.
So once you sign the reset, excuse the sign, seeing your attorney will give the document to you.
Thank you, Your Honor.
Who's here? Noah Guerrero?
Good morning.
Good morning.
Judge, we have submitted the PTD agreement.
Okay.
And I'm requesting, can we reset for July 30th? I have the 29th and the 31st. She told me to ask you because she said the 29th or 31st is 30th. Okay.
July 30th?
Yes, Your Honor.
All right, Norma, July 30th. Yes.
Okay. Thank you, Judge. Just
All right, once you find a recess on your seats. Bill Grant? Mr. Grant, how are you doing?
Doing all right.
All right, counsel, did your client want a bench trial or a jury trial?
Jury trial, he wants to hire another lawyer on it, Your Honor.
All right, so you want to hire another attorney?
Yes, ma'am.
And how long is it gonna take you to hire an attorney?
I hired him like a couple of days ago. And
Oh, you've already hired an attorney?
uh-huh.
And who is this attorney?
Michael.
I'm Michael Sawyer.
All right, so then, and has he filed a notice of retained counsel?
Yes, ma'am.
Oh, then defense, you're excused.
Thank you, Judge.
Thank you. All right, just have a seat. We'll wait for your attorney to appear.
All right, thank you.
Matthew Insuriaga. Hi, how are you doing?
How you doing?
Let me find you on the docket. All right, so docket here starts at 9 a.m., not 9:05, 9:15.
It's not.
You understand?
It's not.
So why were you late?
I was in the wrong courthouse.
All right, so you should have known this is the courthouse you need to be in because you've been here twice before.
Yes, ma'am. No, I just came from the other side, so. I thought I was in the right.
Well, let
place.
me explain something to you. If I were not here, and if there were another judge here, you know what they would do? Take you into custody and give you a remand without bond. There are other judges who sat for me before, and when they call your name and you're not there to answer it, and they're calling the docket, even if they have not finished calling the docket, they would take you into custody. So this is very important, and you need to make sure you're on time. You understand?
Yes, ma'am. Apologies.
All right, Ms. Ferguson, set this for the second week in July. Your attorney is currently in a jury trial.
Okay. Yes, ma'am.
All right, July 8th. Once you sign the reset form, you excuse and make sure you're on time next time, okay?
My apologies.
You're welcome. Who is here on Vanessa Rubio? Hello. All right, are you all ready to proceed?
No, Judge, I need time to get some medical records from her. It's gonna be an open plea to the court.
All right, so if you want to enter your plea now, and then I can reset it for records, but we were here in May for medical issues with your client. And so
Right, that's
now,
what we need.
Yeah.
Yeah, those are the records that we need to get.
all right, if she wants to enter her plea now, and then I can reset it for whatever records you want to obtain.
Yeah, let me talk to her.
All right, sure. Okay, on Gilmore, I don't have a docket sheet. Yes. It's 2024. Oh, just one second. It's towards the very back. All right, State on Gilmore, you're opposed to early term? All right, have y'all spoke to the complainant?
Yeah,
And what does the complainant want?
she's not want early term.
Okay. All right, well, his attorney, Mr. Gilmore, if you've come forward, please. All right, Mr. Gilmore, your attorney is actually in a jury trial, so I'm gonna have to reset it so that he can be here. And present whatever arguments he wants to the court. I mean, you've heard the state, the complainant does not want you to have early termination. That doesn't mean that I'm not going to grant early termination. These are just all things that I consider when making a decision. So we're going to what we'll do is, because it's your attorney's motion, we'll just let the court know when they want it set, and we'll hear it, okay?
Yes, ma'am.
And then your attorney will get in contact with you with the new date. All right, thank you. Thank you so much. No, you don't. What will end up happening is your attorney will call us or come by and say, can you place this on the docket? And we would have released you earlier, but we just received notice that that your attorney was in jury trial.
Yes, ma'am.
All right, so just get in touch with him and he'll put it on the docket and we'll set it.
Thank you.
Excuse me, sir. I'm being told that it may have been filed by probation, a request for early term.
Yes.
All right, so what we'll do is we'll still reset it. Just call your attorney still. All right, thank you. All right, counsel, are you ready on Vanessa Rubio? All right, the court is calling 2023 CR 4281A State versus Vanessa Faye Rubio. Can I have parties announced?
Megan Galloway for the state.
Alfonso Otero on behalf of Ms. Rubio.
Are you Ms. Rubio?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision and State's motion to supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, I did.
Are you the same Vanessa Faye Rubio who was placed on community supervision in 2023 CR 4281A for the offense of theft of a firearm on August 7, 2023 for a term of 4 years? Is that you?
Yes.
All right, state.
Violation of condition number 4 in Bexar County, Texas, the defendant Vanessa Faye Rubio did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, September, October, November, and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
In violation of condition number 4 in Bexar County, Texas, the defendant Vanessa Faye Rubio did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True. And we'll waive and abandon the remainders, Your Honor.
Any objections?
No, Judge.
All right. Did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility?
Yes.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes.
All right, the court will find violations 4 and 4 true. Is there an agreement or no?
No,
No.
Judge, it is the case we talked about that
Yes.
we need the medical.
No, I remember. I'm just trying to see if there's an agreement. All right, we can go off the record. So here's the thing. I did receive information that your client was in the hospital. I think the state is aware of that as well. So the real question is going to be when?
Right.
And are we saying that she was in the hospital for these months that she did not report?
She lost her sight for a while, so we need the documents to see exactly what happened, so the court can consider how that may have impacted.
I mean, I'll consider it, but we go back to whether or not these months that you've pled true to of not reporting, whether or not this was the time you were in the hospital. I mean, that's what I want to know. Because if this is not the time you were in the hospital, then you're being in the hospital, that's just sort of mitigation, but it's not really an excuse for not reporting. For example, April through December 2024, if you're in the hospital for all of that time, then the court will understand, okay, she can't do things because she's in the hospital. But if you were not in the hospital for those days, then the question that I would want, and I'm giving you all this information so that I can get this type of information. The question I would want to know is, where were you and why were you not reporting? And it goes the same for January, February, March 2025. Where were you if you were not in the hospital? You understand?
Mhm.
So if you were not in the hospital during those time periods, you probably need to let your attorney know, because he's going to be seeking certain information to show that either probably that you were in the hospital or that you had some type of medical issue that you were overly concerned about.
Mhm.
And that's why you didn't report. But for the court, it's easy to pick up the phone to call somebody and say, hey, I'm having medical issues. So this is the type of information I'm going to want. But if that information is not there, then don't have your attorney spinning his wheels to get information that does not exist. Do you understand?
Mhm.
Okay. All right. So does this information exist?
I believe that it's considered a factor, yes.
I'm sorry?
I believe it's considered a factor.
All right. So, and you're not an oath. So my question though is, these dates where you pled true to not reporting, were you in the hospital?
I was not in the hospital, no, but I was seeking care for it was it was a big issue at the time. It was concerning for myself, and I spent more time considering that. I did mess up and not call, and that's my fault. I pled true to that.
Okay. And so my understanding, you all don't have an agreement.
No.
And what would you be asking for?
Was just give.
No, I mean, if you
No,
were,
what-
if you're just, I'm just trying to figure out where we are, so I'll know.
Yeah,
What would you
yes,
be asking for?
To keep her on probation, there's ISF recommendation, or whatever the court means necessary to bring the defendant in compliance, and having an opportunity to continue her treatment for her eyes.
All right, and state, what would you be asking
We're
for?
asking for revocation and 2 years in the state jail.
Okay, all right, so now I know where everyone is and you know where everyone is. So how long is it gonna take for you to get the information you're seeking?
I think the jail has him. I mean, I probably can try to, she's going back and sign a HIPAA for me. And once that's done, I just contact the jail and see what they have for me.
So does the jail have this information?
Yes, because I used UT Health for all of the treatment before I was incarcerated as well. So they have access to all the records.
Okay, so then maybe if you have one of the nurses there, if she signs HIPAA, then you can have the nurse Zoom in and testify if you want to do that.
That'd be great, Judge. Yes.
All right. And you say you have vacation. When would this be?
It's on the 26th to the 30th. So this Thursday to Monday. I mean, I can cut it short and come back on Sunday.
No, I mean, Norma, can you recall this for July 8th? All right, is there anything else?
Nothing, Judge.
All right, and then what I've discovered when I was a defense attorney, if you just call over to the jail and ask to speak to the nurse, once you sign your release, they should be able to give him the information very quickly, but you have to do your part, okay? And counsel, if there's an issue with communicating with them, just let me know. And if you want me to see if I could help expedite things, I'll do that.
Yeah.
All right, thank you.
I'm sorry, Judge. You told me, this reset.
Yes, it's going to be reset till July 8th. Defense counsel wants to see if he can obtain some medical records from the jail. All right. William Barnes, come forward. All right, so state. Your witnesses for this case, are these out-of-state witnesses or out-of-county witnesses?
No.
All right, so they would be available beyond this week?
I would think so, yes.
Okay. In just one moment.
I know, we can go, but it's a charter. We've like long time ago.
See, a long time ago, but see, this is what I mean. Everybody agrees on these jury trial dates. I send you all off to Norm and say,
No, this case was set for last week.
and I'm like,
And we were before Judge Angelini, and you know what happened.
mhm. Yeah.
He picked another case.
Judge, they do have, jurors on the 30th, the 1st and the 2nd.
All right. So we would do jury selection on June 30th. And this will be the only case on the docket. So this will be going.
Yeah. Okay.
All right. So we're rescheduling you for June 30th. Your attorney has a vacation. And I always tell people, don't get upset with your attorney for having a vacation, because everybody needs their mental health breaks and to just get away from all of this. There was a time when I would never do a vacation. And a defense attorney told me, he said, Stephanie, you should do a vacation with your family. What are you doing? I'm like, I got to keep working. And he said, Stephanie, if something were to happen to you and you were to die, he said, I would be very sad. But he said, you know what's going to happen? I'm like, what? And of course, you all in your feelings, you're like, they're going to shut down the city. It's going to be a day of mourning. He said, what they're going to do is they're going to say, that's such a shame. And then who's taking our cases? And they're just going to give other people your cases. So attorneys need their mental health break, because attorneys deal with a lot, especially when you're a solo practitioner and you don't get a break. So I'm going to let him enjoy his fishing. Hopefully he will catch something. Yeah. You'll have to show us a photo of you holding the fish.
Oh, yeah.
All right. So we're going to come back on June 30th.
Okay.
All right. And is there anything else, counsel?
Nothing else, Judge.
All right. So we'll bring you back on June 30th. You'll be brought just for trial. We're going to call up the jury on Monday. State.
We're going to do it early in the morning, I guess.
Yes. State, if you'll make sure that you have your witnesses and be ready on Monday.
For testimony to begin on Monday?
Yes.
Yes, ma'am.
And so what will end up happening is, because they have to qualify jurors, we probably won't have a jury out in the hallway till 10 at the earliest. But then we're going to do jury selection. Then right after jury selection, we'll come back in the afternoon for testimony. All right.
And there's the two pretrial motions. It's just a limine and 404B. It's very simple.
All right. What's the motion in limine?
There's a limine and a 404B.
All right. If you'll confer with the state over that, what I can tell you is I don't know anything about your case. The only thing I know is what the charge is. So with regards to motion in limines, which means the defense, there's some things that he maybe doesn't want the state to mention before the state gets ready to question any witnesses about that or elicit any testimony. I'll have the jury step out, and then I'll be able to hear argument, and I'll know better what this case is about and what both parties say and the facts are, okay?
Sure.
And then the 404B,
Mhm.
if you'll talk to the state
I'll
and,
talk to them. I think I have their notice.
okay.
Okay.
All right, thank you.
Thanks, Judge. Maybe excuse their
Yes, you may be
texting me from the
Yeah.
front hall.
All right, Troy Trevino. Why do I have this case? Troy Trevino. Okay, and where is Trevino?
He's right here.
Yes.
Forget where I'm standing.
Oh, you're right here?
Right.
All right. Yes.
Yes, Judge. So my client has he has several cases, one with several with family violence and several with criminal trial division. They are working together to try to get us a comprehensive deal and first offer as a first setting. Even a 2-week reset just to give them some time to get us a first offer. We come back and see what we can do from there.
All right, Ms. Ferguson, if I can have a 2-week reset on Trevino, please. And just set it as discovery. And state, will you have an offer by that time?
We should, yes, Your Honor.
Is
All
it
right.
possible to do the 9th? Only because the 8th is getting complicated. Could we do the 9th the very next day?
All right, the 9th. Do it for the 10th then.
Thank you, Judge.
The 10th, Norm, is that okay?
Yes,
All right, we'll bring you back on the 10th. Do you have any questions?
Thank you, Judge. May we excuse?
Yes. Let's hear on Leon Small.
I am your. Yeah,
Yes.
Mr. Small is in the custody of the Bureau of Prisons, or at least in federal marshal custody. He's got a federal case. I brought the court, the docketing sheet on his federal case off of Pacer, as well as his federal indictment, as well as, there's an order of detention, which is not contained in there, but there's reference to it. He was detained without bond over there. And I think his next, if you look at the very back page, there's an order, setting a plea deadline.
Okay.
Yes, ma'am. So I think I'm not representing him on the federal case, but I think, I hate to use the word artificial, but I don't know. I mean, these dates are certain dates for right now, but
They may change.
it will change. I believe.
Ms. Ferguson, I need a date in August for Mr. Small, late August, please.
And Judge, I hate to ask you this, but and anyone that could help me on it, is he showing up on bond, or is there a way I could make an oral motion, or does the court need me to file a written motion to go ahead and go off his bond, just so at least he's accumulating credit?
What I can tell you in this court, I mean, if you want to do that, of course, the court will do that. But in this court, your client has been in custody and he hasn't made bond. And if for some reason he were sentenced on this case, I would give him credit for the time that he's been in federal custody while this case was open.
Very well, Judge.
Because sometimes he may be found not guilty. Then he's like, I don't have a bond.
Right.
All right. What date, Ms. Ferguson? All right. Is there anything else, counsel?
No, ma'am, Your Honor.
All right. Good seeing you.
Pleasure seeing you.
All right.
Thank you, Judge.
You too. Joe Grant?
Your Honor, Mr. Grant is on today's docket. I was
Yes.
just hired yesterday at 5
Okay.
o'clock.
All right, Ms. Ferguson. I need a jury trial date for Mr. Grant, and if it works out, then there will not be a jury trial. So can you set this in July, please? Criminal Trial Division. It's a possession case. It shouldn't take that long. All right, July 22nd.
That's good, Your Honor.
All right, and that'll be your jury trial date and plea deadline date, and you can ask your client if he would like a bench trial.
I will do that, Your Honor.
All right, and Norma, you said the 22nd? All right, once you sign the reset form, you're excused.
Thank you very much.
Thank you.
Have a good day.
You too. We'll see on Cameron Scott.
You have two files on Mr. Scott, Judge, that 2021 case has already been terminated. That was, that's expired already. That was terminated.
Okay. So that just leaves there.
This is the 2017 clause number. Did you need a copy of the request for early term? Because this might be, those might be the older copies.
Okay, yes, I think it is. It's from October.
Right.
All right, so what I can tell both parties. is one of the issues with this case is he has prior motions to revoke. Am I reading that correctly?
Yes, Judge, those prior motions to revokes were years ago, some years back, 2020, I believe. And based on that motion to revoke, he was placed on deferred adjudication in that case for 3 years. And that 3-year term is coming on. He's already successfully completed that term. During that motion to revoke, he was extended 5 years on this probation term. So that's what happened with the motion to revokes. Or the latest one.
So basically he has about 2 more years on this.
2027, Judge. We have sent, this is the 3rd request for early termination that we've sent in, one in February of 2024 and one in November of 2024.
All right. And State, have you reached out to the complainant?
We have, Your Honor.
And what is she requesting?
Your Honor, at this time, the complainant is requesting that the defendant remain on probation. We did speak to her about several instances that have occurred after these NTRs. One being very shortly after he was released from GPS on the NTR in 2021, he went over to the complainant's residence and was knocking on the door and stayed outside of her residence for
And
quite some time.
What year was this?
It was in October and November of 2021 after the last NTR. They did not report that to the police because she did not want any more drama with the defendant and didn't want to just cause anything else. So she did end up just leaving that residence. And then last year, the defendant reached out to her on TikTok and sent emojis and changed his profile picture to her profile picture. And the complainant did tell us that it just seems like nothing has changed and that he's going to continue reaching out to her and bothering her. Additionally, Your Honor, the state just looks at the defendant's criminal
Well, let me
history.
ask this. So let's go back to the TikTok thing. I don't know about TikTok and how it works really. So what's the proof that he did that?
Your Honor, I mean, I can have, I'm just proffering what the complainant has told me. If you would like to hear from the complainant, we can do
Well,
that.
I mean, I need some proof of things that are being said instead of just people saying it. I remember this case. I remember all the cases. And I remember this case in the very beginning, there was an issue with the complainant not being cooperative. And I understand when complainants are not cooperative, then they change their mind and different things happen. But if there are reports that just last year he was reaching out to her, then I need more than just somebody saying that. I need proof of that. So will you be able to provide proof, or if she wants to come in and give testimony, she can come in and give testimony?
Sure, Your Honor, she is available. She's ready right now to give testimony if the court would like to hear it.
All right. So do you have an attorney? No. All right. And you were given a court-appointed attorney previously? Yes. All right. So we will see that you have an attorney. Just one moment.
When are we setting that, Judge?
How
long is this to get the attorney?
I'll probably do a court-appointed attorney.
Well, now here's the thing. You have to be interviewed to see if you qualify. You just can't say.
I like to be interviewed.
All right. Ms. Ferguson, if you can see if he can be interviewed for an attorney.
Yes, sir.
All right. All right, who's here on Amanda Hernandez?
First, Gerard.
And then after Amanda Hernandez, it'll be Leroy Beal.
Where you go?
We would file for us.
No, I don't have that. Everyone, if I have not called your case, it's because I don't have your file. All right, the court is calling 2025 CR 00174 and 2025 CR 007073. State versus Amanda Hernandez. Can I have parties announced?
Rick Pena for the state of Texas.
John Young for the defense.
And are you Miss Hernandez?
Your Honor, it's an oddity in the system, but I have two Amanda Hernandez's right now, so I would ask that she be identified as Amanda Marie Hernandez.
You are Amanda Marie Hernandez?
Yes.
Counsel, in each of the cause numbers, did you receive all of the discovery and did you review it with your client?
Yes, Your Honor.
In each cause number, the court will find that the state is in compliance with discovery. In each cause number, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it?
Yes.
Counsel, I'm sorry, Ms. Hernandez, in each cause number, did you review the documents entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
And counsel, do you waive the reading of the indictments?
I do, Your Honor.
State, are you proceeding on the indictment as presented in each cause number?
For both cases, yes, Your Honor.
Ms. Hernandez, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
In the cause number ending in 7-4, you're charged with fraudulent use or possession of identifying information less than 5 items. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
And the cause number ending in 7-3, you're charged with injury to a child or elderly or disabled person, bodily injury. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
I did.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call on the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cases? Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes,
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe she is and was.
Mr. Hernandez, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargaining agreement with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, the causes are to run concurrently. The state is taking in consideration 2024 CR 011068. In the cause number ending in 73, there's a affirmative finding of family violence. There's to be no contact with the complainant or the complainant's address. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as a primary custodial parent?
Yes.
And in the cause number ending in 7-4, yes,
I believe with the 7-3 case, there was a fine as well.
a $1,500 fine.
And I'm going to
Then the
be
court is
asking the
gonna
court to probate that. Your
Yeah,
Honor.
I will probate that.
Thank you.
All right, and then the cause number ending in 7-4. There is to be restitution to Audrey Bash, Roberto Alfaro, Arturo Olivares, and that's to be determined. Did you understand that to be the plea in each of the cause numbers?
Yes.
Defense is at the plea.
Yes, it is, Your Honor. I have also told my client that if there is any objection to the amount that probation determines as restitution, that I will ask for a hearing on restitution with the court.
All right, state is at the plea.
That is the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
There have not, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 6 years. There'll be 100 hours of community service restitution, no contact with the complainants, anger management, TAP evaluation, follow all recommendations in MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then in cause number 2025 CR 000174, how do you plea?
No contest.
And in cause number 2025 CR 007073, how do you plea?
No contest.
State any evidence.
As to both cases, Your Honor, state offers into evidence, State Exhibit 1 with all attachments.
No objection, Your Honor.
All right, and state, have you spoken with the complainants?
We have, she's here, and at the conclusion, she'd like to give a victim impact statement.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand that by entering this plea, again, you're giving up your right to jury trial, a right to remain silent, and the right to cross-examine witnesses?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and will review the same.
Yes.
All right, in each cause numbers, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I know that she, even though I am retained, that she does not have any money in her own name. I was hired by a gentleman that is a friend of hers. I know that he intends to abide by this. I've explained to her that the court normally will review a request for early termination if she completes everything she does, has indicated to me she intends to try to do that.
All right, do you have any children?
Yes.
What are their ages?
They're a year older than 18.
All right, what are their ages?
25, 19, 18. The other one, 23.
You don't know?
I don't.
All right.
He wasn't in my life.
All right. When's the last time you were employed?
Prior to coming into jail, so about 4 months ago.
Doing what?
Care.
And who were you caring for?
My best friend and 2 neighbors of his.
All right, who is Oscar Lara III to you?
Oscar Lara.
The person you were in the vehicle with when all of these cards were found.
In the vehicle, I was by myself.
Yeah. According to the stipulations, it says officer observed a male and female enter the Lincoln, and that's the Lincoln vehicle. Yeah.
Oh, that's Paul.
No, there's a Oscar Lara III. That's a different person. And you also have Paul Vasquez Jr.
Yes, Paul Vasquez is the one that was in the driver.
All right, so who is he to you?
A person I hung around with.
And who is Oscar Lara III to you?
That I don't know. I don't know that person.
And who is Roberto Alfaro to you?
My ex.
All right, when's the last time you used any type of drugs?
About 7 months ago.
And what do you use normally?
Heroin.
Okay.
I've been on Suboxone that's how I got off of it prior to coming over here.
All right, I understand when people say they're off of drugs and then they get on another drug, so they won't use the drug.
But I had to stop. But yeah,
I mean, it's still a drug, right?
I understand.
Do you have any violent history?
No.
All right, this is what the court is going to do. In cause number 2025 CR 000174. The court is finding there's sufficient evidence to find you guilty. The court will defer finding of guilt. The court will sentence you to 5 years deferred adjudication. This will run concurrent with 2025 CR 007073. Take into consideration 2024 CR 011068. There's to be restitution to Audrey, Audrey Bash, BASH, Roberto Alfaro, Arturo Olivares, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home healthcare provider or with minors, no residing with minors or the elderly. Field visits 1 time per month until further notice. There's to be a referral to felony drug court and Esperanza court in custody. And there is to be 150 hours of community service restitution and 60 sober support meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court with regards to that case?
No.
And cause number 2025 CR 007073. The court will sentence you to a $1,500 fine. That will be probated. This will run concurrent with 2025 CR 000174. Take in consideration 2024 CR 011068. There's an affirmative finding of family violence. There's to be no contact with Myrna Espinoza Portillo or Yukon Boulevard. $100 hours of community service restitution, anger management, proof of employment within 45 days, no employment as a home healthcare provider or with minors, no residing with minors or the elderly, field visits 1 time per month until further notice, a referral to felony drug court and Esperanza court. That's to be done in custody. And in each cause number, there's to be a TAP evaluation in custody, follow recommendations. And there's to be 60 sober support meetings in 60 days. Probation, is there anything else? Is there anything else you need from the court in regards to that case? And each of the
This cause number.
the term on this cause number is 6 years.
Your Honor, can I ask you to reconsider the referrals to both Esperanza and drug court in custody? I know that my client, part of her reason for entering these plea bargains was in order to get out of jail.
No. You need help. You have a drug or alcohol problem, and your drug or alcohol problem is what brought you here today. You understand?
Yes.
All right. Did you review the documents entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because these are plea bargain agreements, because I followed your plea bargain agreements, and because you waived your right to appeal, you do not have the court's permission to appeal. And cause number 2025 CR 007073, because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. In this court, communication is key. If there is an issue, you need to let your probation officer know about it. If you feel as though they're not addressing it, you can always come back to the court. Do you understand? All right, so here's the other thing. You're not allowed to be a home healthcare provider. You're not allowed to take care of the elderly. You're not allowed to take care of minors. If you do any of those things, it's going to be a violation of your probation and a motion to revoke is going to be filed. You also are not allowed to live or reside in any household where there are minors. Do you understand? And where there are elderly persons. You understand? All right, good luck to you.
Your Honor.
Yes.
The definition of elderly is sometimes a little fuzzy. My interpretation of that is it's a person over 65 years of age.
All right, so let me clarify. How old are you?
I'm 45.
You're 45. You cannot, Vashan, for her, 45 is 10 years older than whatever she is. So you're not allowed to live with anyone who is 55 or older. You understand?
Okay.
All right, thank you.
Your Honor.
And my understanding, there's a victim impact statement.
Yes.
Just for Your Honor's edification, if it's okay, the victim would like to give it in Spanish.
Do you speak Spanish?
If I do, yes.
All right, so she wants to speak to you in Spanish. All right, thank you. You too. Who's here on bill?
Here, Your Honor.
Court is calling 2025 CR 002530, State versus Leroy Bill. Could I have parties announced?
Andrew Harris, Tatum, the state.
Fernando Ramos for the defense.
And you all are here to enter a plea?
Yes, ma'am.
All right, counsel, have you received all discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Bill, did you review the document entitled Application for Community Supervision or Deferred Adjudication with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge. Waive the repeat offender enhancement allegation.
Any objection? All right, Mr. Bill, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with unlawfully carrying a weapon with a felony conviction as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison? Did you understand that? If you were not to do well on your probation, then I could sentence you up to 20 years. Did you understand that?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He has been evaluated by a psychiatrist, determined he is competent, Judge, and I agree with that.
Mr. Bill, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
All right, according to the plea, punishment is to be assessed at a cap of 8 years in the prison, and the state is silent on your application. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
It is, Your Honor.
State is at the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that to waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand?
Yes.
Counsel, are there any such motions?
None, Your Honor.
Then to the offense is charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Contained in Exhibit 1 and attachments.
No objection, Your Honor.
All right, state you may be excused. Did you review the document entitled waiver and consent to stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
All right, off the record. There is no judgment in here. All right, we're back on the record. All right. Did you review the waiver and stipulations with your attorney? Did you understand it? And did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Any objections to the amendment?
We have none, Judge.
All right, we're off the record. So here's my question. I always say, I don't know all of the law, but is it illegal to smoke in a city park?
I believe it is, Your Honor.
Well, I mean, let's not go on beliefs.
I don't know.
Is there a law? Does any attorney know? We're off the record. Does any attorney know whether or not it's a legal and arrestable offense to smoke in a city park? I don't know that off the top of my head. All right, so for both parties, the first hurdle I need to get over to see whether or not there's an issue here is for whether or not it's illegal to smoke in a city park, because they're saying that they arrested him for smoking in a city park, and then that led to everything else. So I don't know the answer to that. So if you all can come back at 1:30.
Judge, my wife has been very sick. Been up all night with her. She had spinal surgery about 30 months.
Are you able to appear by Zoom?
I'm sorry?
Are you able to appear by Zoom?
I didn't hear you.
Are you able to appear by Zoom?
Yes.
All right, so you can come back by Zoom.
Yes, ma'am.
All right, if somebody could make sure that Mr. Bill is back by 1:30, and I'll research to see that answer, because I don't know that one off the top of my head.
Thank you, Judge.
All right, thank you. No, it's probably best that you not say anything. All right. All right, who's here on Vincent Savage? Norma Bill is going to come back at 1:30. All right, so in this case where you're on
Yes,
discovery.
ma'am. I conferred briefly with Mr. Edelman.
Everyone, please whisper.
I was told that it's been re-indicted. They don't have the file down here. They're looking for it. So I haven't had a chance to review it today. I also don't, as of now, I don't know. They're still looking into whether or not they've spoken to a victim, so.
All right, Ms. Ferguson, I need a 3-week reset date, please, on Savage. All right, July 10th.
Yes, ma'am. Thank you, Judge.
All right, we'll come back on July 10th, sir.
Thank you, Judge.
Your email, Judge. Thank you. Who is here on Ricardo Vargas?
Hello, Judge.
Hello. So today is plea deadline date.
It is plea deadline date. However, Judge, there's one other discovery matter. I haven't looked at the body cam that I needed to, and I know I needed to do that last setting, but I haven't got it done.
All right, Ms. Ferguson, can we recall this in 3 weeks, please?
Yeah.
All right, that will be your final plea deadline date.
Thank you, Judge.
All right, anything else, counsel?
Nothing else, Judge.
All right,
That's all
once
we-
you sign the reset form, you are excused.
All right, thank you.
You're welcome. Dorian Camarillo? Hello. All right. Hello. So on this one, we're still doing discovery, correct?
Oh, that's correct. You got extra change going.
Yeah, sometimes. It reminds me of, every year we would watch the Ten Commandments. Oh, no, not Roots, but Ten Commandments every Easter. And you know what he said? If he a myth, bring him to me in a bottle. If he be a man, bring him to me in chains.
Like that.
Oh, that was a program. We still watch it. That's an Easter classic, right?
So it be written, so it
Be done. I'm gonna violate my final law on my deathbed and say his name. Moses. All right, so we're coming back on this case on July 24th.
That's correct, Judge.
Okay.
Now, another thing that we have is there's a motion for a bond reduction.
All righty.
So
Are you able to come back at 1:30 and I'll hear that?
you might get 1:30.
All right, Norma Camarillo is 1:30 for a motion to reduce bond. We'll pick it up. Greenwood. So how are you doing?
Hey, Judge, how are you?
All right, on this case, she hasn't entered a plea, has she?
Not yet, Judge.
All right, the court is calling 2017 CR 6646B, State versus Imari Greenwood. Could I have parties announced?
Megan Galloway for the state.
Alma Benavides from Miss Greenwood.
And are you Miss Greenwood?
Yes, ma'am.
All right, Miss Greenwood, did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke probation with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Amari Raisha Greenwood who was placed on community supervision in 2017 CR 6646B for the offense of theft of property $2,500 to $30,000 on January 24th, 2023 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bear County, Texas. The defendant Amari Raisha Greenwood did then and there fail to report to the supervision officer as directed for the months of August, October, and November 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
Violation of condition number 4 in Bear County, Texas. The defendant Amari Raisha Greenwood did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, and May of 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True. We waive and abandon the remainders, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to 4 and 4, the court could find it true, grant the motion, sentence you up to 1 year in the state jail facility?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes, ma'am.
Court will find violations 4 and 4 true. Is there a proposed agreement?
Judge, there is, after conferring with probation, the recommendation is to deny the state's motion, extend the defendant for 1 year, alter and amend her conditions for SADF, followed by aftercare, an updated TAP evaluation to be performed in custody, monthly UAs upon release, and sober support meetings.
All right, what has she done on probation? Has she done anything?
Judge, I do want to point out the top evaluation was already complete. That was done last month, and that is the new recommendation is for the SADF.
I don't think you're a good candidate for probation. Well, let me just tell you why. This is not your first motion to revoke. And it's the same thing. And in 2023, you were here for a motion to revoke. And a TAP evaluation was done. They did GPS. So, I mean, what have you been doing since then? You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Imari Raisha Greenwood.
All right, so what have you done since you've been on probation?
I got my GED.
Oh, that's great.
Yes,
Okay.
ma'am. I'm in school currently. I'm going to cosmetology school, and I enrolled in Southern University working in my associate's degree. I understand that I messed up, and I'm truly sorry. I'm not the same person I was last time you saw me. I totally made a turnaround in my life. I'm tired of this. I'm almost 30. I just want to move forward in my life. I understand I messed up. Yes, I just truly want to move forward. In between time, I was going through a lot. It's not an excuse because that wouldn't make it. That didn't make a difference. But I truly am a different person, and I have stuff going on out there. And I do not want to be locked up. I'm tired of this. I just want to move forward.
Okay. All right, off the record for a moment. All right. So here's the thing. They want you to be continued. I can continue you. I don't know if you're going to be successful on this or not.
Yes, ma'am.
Or I can send you to the state jail facility for 180 days. And the reason why I'm saying 180 days is because of the fact that you've obtained your GED, and I'm glad you're on the right track, and that you have, worked towards rehabilitating yourself. So this is what you need to think long and hard about. The 180 days, you do your 180 days, you'll be done. You get credit for whatever time that you've previously done, or you're going to continue to be on probation. You're already on regular probation, which means this is already a felony conviction. So if you want to discuss that with your attorney, you can. And if you want to talk to them to see how much time she has.
She has, I believe, Judge, according to probation, she has 227 days credit.
Well, what I can tell you is, because this is a state jail felony case, they may release you from the jail, but legally what they're going to do is they're going to take you and process you at the state jail facility. And if you have credit that's beyond 180 days, they'll release you from the state jail facility.
You want to do that? Your decision.
All right. So here's the thing. We're out the record. Here's the thing. It's your decision. This is what I'm telling you. And I want you to hear me and internalize what I'm saying. For a lot of people, going to the state jail facility, going to the Bexar County Jail, going to prison, that's a frightening experience, right? We don't know what's going to happen. But what I can tell you is I'm willing to send you to 180 days at the state jail facility. State jail facility, that's day for day time. What everybody is telling me is that you've already satisfied that time. But because it's a state jail facility, normally and legally, they don't release you. They're not supposed to release you from the Bexar County Jail. Now, I've heard situations where people have been released from the Bexar County Jail, even though they're supposed to be processed through the state jail facility. What I'm telling you is legally, they're supposed to take you to the state jail facility, process you. They'll see that you have enough days for the judgment to be satisfied, and they'll release you from the state jail facility. Otherwise, you're going to be on probation in this court for another 2 years.
I'll do the 186.
All right. Are you waiving your right to appeal?
Yes.
Well, not I guess. So if you want me to give you the 180 days, then that's something that you're asking me to do. That's something that your counsel is asking me to do. And I think the state is going to be asking me to do that. And do you want me to follow that?
Yes, ma'am.
And are you waiving your right to appeal?
Yes, ma'am.
All right. The court is finding violations of 4 and 4 true. The court will sentence you to 180 days in the state jail facility, give you credit for any time served. The court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You don't have probation hanging over your head, but you still need to remain vigilant, because otherwise you're going to end up right back here. Don't be celebrating, woo, I'm off of probation. Ooh, I'm out of jail, because that's when you start backsliding. So write down what your program is for your life and follow that program. And anybody who tries to stray you from that path, you need to kick them to the curb. You understand?
Yes, ma'am.
And I'll be here. If I'm here when you get out and you can't find what you're looking for, you can come back here and we can look online and find a place for you. Okay?
Yes, ma'am.
All right. Good luck to you.
Thank you, Judge.
You're welcome.
Good to see you.
You
Thank
too.
you. Be excused.
Yes. Who's here on Constance Sinwell? Yes. Good morning. Where's your client?
She's in the back, Judge, but we're just here to for a status on the doctor.
Mm-hmm.
What I was told by court administration and everybody else that I didn't know is that I guess she's just supposed to be referred to mag court and they will do the evaluation.
That's not how that's supposed to be, because you're requesting a sanity evaluation, correct?
Well, I just did a notice of insanity, Judge, and
All right. So you're just doing sanity?
just insanity, not competence.
All right. So yeah, you have to file a motion for that, and they should take care of it in the magistrate's court.
Correct. Okay, so okay, Judge, well, maybe I'm
Yeah.
done on insanity defense in
No,
20
I hear
years. Okay, I thought it should just be a bird on my notice. I can file that motion today, Judge.
Yes, awesome. And then check in with them.
Okay, we'll do.
All right, Norma, recall this for the 28th. January, July.
Judge, I'll come check in when I get that done too.
All right, thank you. Court is calling 2025 CR 005464 State versus Joseph Greenwood Smarto. Could I have parties announced?
Megan Galloway for the state.
Monica Guerrero for Mr. Smarto, Your Honor.
And counsel, is this an application?
It is not.
Okay. Are you Mr. Smarto?
Sure.
All right, counsel, have you received all discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Smarto, did you review the true bill of indictment with your attorney?
Yes, Your Honor.
Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the habitual enhancement.
And we have no objection to that and believe they're only proceeding on count one.
Yes, that's correct, yeah.
All right, Mr. Smarto, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with a manufacturing delivery of a controlled substance, penalty group 1, 4 to 200 grams as a first-degree felony? Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights in this case?
Sure.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Smarto, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Sure.
According to the plea, punishment is to be assessed at 8 years in the prison. There's a $2,000 fine and no applications. Did you understand that to be the plea?
Sure.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal?
Yes.
The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to count one in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence to support the defendant's plea?
State offers states one in attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
He's been very honest from the get-go, including in the police report. We'd just like the court to accept his plea agreement.
All right. The court will find you guilty. The court will sentence you to 8 years in the prison. Give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. Fast money, not good money. I bet you end up with fast money and you don't even know where it went. You can't point to anything and say, that's what I bought it with. This is what my grandmother would always tell me. And I do my best to live by that. And she said, you cannot build your happiness off somebody's misery. And there are people who are suffering from drug addictions, and you can't build your happiness off of that. You understand? When you're released from prison, if you have an issue with drugs yourself, if you have an issue with housing or whatever it may be, if I'm still here, you can come by. I will pick up the phone and call someplace to help you. Okay? All right. Good luck to you.
Thank you.
Thank you.
Have a big excuse?
Yes. All right. So on Mr. Bill, I thank you, Cindy, and thank you, everyone. You cannot smoke in a park. Who knew? Cornelius, did you know you're not allowed to smoke in a park? Just smoke, period. No, period. You're not allowed to smoke.
But it has to be designated.
No, it's some sort of city ordinance. Alrighty, if you'll bring Mr. Scott up. Let you know, my grandmother always said, if you don't learn something new every day, then you wasted a day. So I just learned the ordinance. I had no idea. All right, the court is calling 2025 CR 002935 State versus Terrence Lamont Scott. Could I have the parties announced?
Megan Galloway for the state.
Todd Lessard for Mr. Scott.
And are you Mr. Scott?
Yes, ma'am.
Counsel, have you received all discovery and did you review that with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Scott, did you review the application? You need this?
Yes, ma'am.
Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we moved to proceed on the lesser included offense of felon in possession of a firearm, the third degree.
Any objections?
None.
Mr. Scott, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand the state is proceeding on felon in possession of a weapon as a third degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Scott, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense of felon in possession of a weapon. They're asking for a $2,000 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
None.
Outside the agreement, the state is recommending that you defer adjudication before a term of 6 years. There'll be a TAP evaluation, 200 hours of community service restitution, and the MRT course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Good.
State any evidence.
Did offer states one in attachment?
No objections.
All right, state two may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client has not been in trouble with the law for quite some time. He certainly has turned his life around since he was previously in trouble. He wants to put this behind him. He's gainfully employed, and we'd like the court to please follow the sentencing recommendation.
All right, if you're drug tested today, what are the results going to be?
Good.
For what?
Marijuana.
Why are you using marijuana? Just want to?
No, ma'am.
All right, so why are you using it?
Just using.
Well, the just because needs to stop. You understand? Do you have any children?
One.
Age?
11.
And what do you do for a living?
I work at warehouse.
Doing what?
Assembly work.
And do you drive around with your child sometimes? Have them in the vehicle with you?
Yes, ma'am.
All right. No child wants to be in a vehicle that smells like marijuana.
Yes, ma'am.
And when you're around a certain scent for a long time, as the commercial says, you go nose blind to it. And you may think your car smells fine, you know, you're spraying it, you're cleaning it. But to other people who are not around marijuana, it just hits them in the face. And you're 11-year-old, you don't want them to grow up smoking marijuana, right?
No, ma'am.
So you're going to have to set a better example for them. You understand?
Yes, ma'am.
All right. How far did you go in school?
High school. Graduated.
All right. So what do you want to do with the rest of your life?
I want to drive trucks.
What are you doing to make that happen?
Right now, I'm just working to pay tickets.
All
So I
right.
can get my license back in.
All right. So you can't just be waiting for that. You got to start setting goals so you can meet that goal. You understand?
Yes, ma'am.
All right. This is what the court will do. The court will sentence you to 6 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, tests for levels, proof of employment within 30 days, no employment as a home health care provider or with minors, 200 hours of community service restitution. 100 of those hours will be deemed satisfied upon completion of parenting classes. The remaining 100 hours will be deemed satisfied if you obtain your CDL. So the 100 hours, you can either get your CDL or you're going to have to do those 100 hours. That's completely up to you. You understand?
Yes, ma'am.
But the parenting classes, I'm requiring that. There is to be field visits 1 time per month for 3 months. A $2,000 fine. That will be probated. Probation, is there anything else? All right. And probation, if you feel the need, we can do a TAP evaluation out of custody. If his levels go up, just schedule the TAP evaluation. Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. Do better. All right, in this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can come back here and address it with me. You understand?
Yes.
All right, good luck to you. You're welcome. All right, Mr. Bill, if you'll come down, please. All right, we're back on the record in 2025 CR 002530, State versus Leroy Bill. If I could have parties re-announce for the record, please.
Andrew Harrison with the state.
All right, and you're Mr. Bill, correct?
Yes, ma'am.
All right, so Mr. Bill, we ended up taking a recess because I wanted to be sure about the law. I don't know every single law there is, especially city ordinances, because if that doesn't come before you on a regular basis, you just really have no need to look up what different city ordinances are. So, counsel, I was given some case law by an attorney, and yes, there is no smoking in city parks. So that's where we are. So after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will, let me see, I think there's an application for deferred in this. All right. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Judge, we have requested a PSI.
Are we proceeding with sentencing?
State's not recommending probation.
They're silent. Are you proceeding with sentencing?
I assume there was going to be a PSI, Judge. If you wish to proceed, we can.
All right. Are you waiving PSI?
Yes, ma'am.
All right. Anything you wish to say on behalf of your client?
My client is 65 years old, Judge. He is receiving checks. He lives with his sister. He is been declared competent by a psychiatrist. My opinion is that he is close to getting borderline to senility, Your Honor. He doesn't pose a danger to the public.
I'm sorry, what did you say?
He does not pose a danger to the public, even though he had a weapon. His prior conviction is from I can't recall, but it's almost 10, 15, 20 years ago, Judge.
It's from 1988.
Yes, ma'am. We'd ask that you grant the application for deferred. He would be able to meet all of the conditions of probation, along with his sister helping him.
All right. All right, Mr. Bill. If you were released, do you have a place to stay?
Yes, ma'am.
And who would that be with?
On 1710 hours.
No. I mean, who would you be staying with?
With my sister.
All right. And have you talked to your sister? Does she want you there?
Yeah, she paid my rent.
Okay.
Cause I see what happened is I had to divorce my wife to get my disability.
Mm-hmm.
And my sister moved in my house.
Okay. All right. So, Mr. Bill, here's the thing. You are not allowed to have any type of weapon, no firearm or anything, and it's because of your conviction from 1988. You understand?
Yes, ma'am.
Now, with regard to your mental health, I know previously there was an evaluation done, and it took a while for you to become competent. Do you have access to mental health treatment or no?
Yes, ma'am.
All right. Do you already have a doctor?
Yeah, I was waiting till my Medicaid kick in.
Okay.
And it's gonna kick in thoroughly when I'm 66.
Okay. And how old are you now?
I'm 65.
Okay. And when will you be 66?
February 23rd.
Okay.
1960. No, that's when I was born.
No problem. So this is what we need. You're going to have to go through Center for Healthcare Services because I want to make sure that your mental health is taken care of. Do you understand? And it's very important that you follow my instructions to the letter, all right?
I
So-
take the irritability pill,
Which pills?
the irritability pill, to keep my mood swing right.
Mm-hmm.
And don't be getting upset if I'm too old for it. I don't want to catch no stroke.
Okay. All right. So this is what the court is going to do. The court is going to sentence you to 4 years deferred adjudication. Now, deferred adjudication, what that means is if for some reason, if you don't complete it, or if you are revoked, you're looking at 20 years in the prison. You understand?
Yes, ma'am.
So it's very important that you complete everything. All right.
Yes, ma'am.
There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment or SSI within 60 days. There should be no employment as a home health care provider or with minors. Field visits 1 time per month. And probation, we'll do the field visits until he's under the care of a mental health physician. So, and a referral to Center for Healthcare Services. And they did say he had marijuana, so just do a TAP evaluation and that can be done out of custody. Probation, is there anything else? Is there anything else you need from the court to be successful on this probation?
No, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal? Here you are, sir. Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement and because I followed your plea bargain agreement, you do not have the court's permission to appeal, all right?
Okay.
All right, we can go off the record. So if something happens and you need help with something, let your probation officer know. If there's an issue with reporting or something, let them know. Now, if it's something that they say they can't help you with, then it's not in their job description. They can't help you with it. But if you have a question about something or you need help with something, you can always come back to the court, okay? All right, thank you.
The lady at the SSI, excuse me, she told me I can only work 4 hours.
Well, so this is what I said in my order. I'm not requiring you to be employed, but I've given you a time frame to either get employment or let probation know this is my SSI. So if you're receiving your SSI, then you don't have to get employment. Okay?
Okay.
All right. And at your home, is it just you and your sister?
Yes, ma'am.
All right. All right. Thank you, sir.
You're welcome.
Okay. Thank you, Mr. Ramos.
Your Honor, one last thing, just for my client's benefit. We talked about a fine and community service. If you would pronounce that there would be no fine, or that if there is a fine, that be probated, and that the community service also be probated.
There's no fine, and I didn't order any community service, so there isn't any.
Thank you, Judge. Appreciate it, and I appreciate you letting me appear by Zoom.
Oh, you're welcome. Who is here on Rosa Ibarra? Court is calling 2020, and I'm sorry, Norma?
Yes.
Mr. Bill stated, if you all have no objection, can you see maybe they'll take him in mental health court? Because I really think it's a mental health court issue and not so much this type of issue. All right, so yeah, do the referral and put in bold that they can file a motion for new trial. All right, thank you. All right, court is calling 2024 CR 012059, State versus Rosa Ibarra. Can I have parties announced?
Megan Galloway for the state.
Joseph Davidson covering for Monica Guerrero, and will you give this court permission for me to do this in place of Ms. Guerrero?
Yes, ma'am.
And are you Ms. Ibarra?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Ms. Ibarra, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Ibarra, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Ibarra, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain paid with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 22 months in the state jail facility. There's a $2,000 fine, no applications. The state will take in consideration 2024 PF 12276, and there's restitution of $180 to DPS. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Plead offer states what in practice.
No objection.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? You need to speak up.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor. We ask that you follow the agreement. We give her credit for her back time that she served.
All right.
Run the money concurrent with the time.
All right. The court will sentence you to 22 months in the state jail facility, give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. Take in consideration 2024 PF 12276. There's $180 restitution to DPS, and I request the therapeutic community. The therapeutic community doesn't increase your time in custody, but it is to help you with any type of controlled substance abuse you may have. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question about that, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So here's the thing. If you use drugs, only one of two things is going to end up happening if you don't stop. Either you're going to find yourself living the majority of your time in somebody's jail or at somebody's prison, or either somebody's going to end up identifying your body. Those are only two choices with drugs, right? So when you're released from the state jail facility, if you can't find a place that can help you with your addiction, if I'm here, you come back here, I'll pick up the phone, call somebody to get you the help you need. All right. You're welcome. Good luck to you.
Thank you, Judge.
You're welcome.
Bye-bye.
All right. Who's here on Christopher Guerrero? All right. There's an application in this case or no?
There is, Judge.
Court is calling 2025 CR 003046, State versus Christopher Anthony Guerrero. Can I have parties announced?
In comparison to state.
Joanne April for Mr. Guerrero.
Are you Mr. Guerrero?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Guerrero? All right, we're going to go off the record. All right, we're back on the record. All right, Mr. Guerrero, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I did.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Guerrero, did you review court admonishments and defendants waivers with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with driving while intoxicated third or more? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call them the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Guerrero, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine and state recommends community supervision. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is requesting that your community supervision be for a term of 8 years. There be 200 hours of community service restitution, 2-year driver's license suspension, ignition interlock for the full term, and 60 days in the Bexar County Jail as a condition. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Exhibit 1 of the attachments.
No objection, Judge.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call them the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Listen, Judge.
All right, anything you wish to say on behalf of your client?
Judge, I guess in regard to the plea bargain agreement, I'd like the court to be aware that my client spent 4 months in jail prior to making bond on this offense. And ask the court to run his probation CC. He's currently on probation for a misdemeanor offense. He's already done a TAP evaluation. He's taking the victim impact panel class.
And what is the cause number for the case you're asking that it run concurrently with? Is that one of the cases in the indictment?
I believe it is. Yes.
Is that the April 24 case? 2024?
Yes.
Yes, that's it, Judge.
All right, so for the record, that cause number is 72460. And I'm sorry, counsel, what else were you saying?
That my client is starting outpatient treatment on Thursday.
Oh, anything else?
Yes.
He's also
And I'll work
employed. Yeah, he has a full-time job.
All right, what do you do for a living?
Landscaping.
I'm sorry, what?
Landscaping.
All right, why do you keep drinking and driving? Obviously, you're a person who can't drink alcohol because you don't know when to stop.
Man, I was hanging out with the wrong people, Judge, and I'm glad I got that out of my life. You know, I'm spending 4 months in there, just
No, so let me just tell you, when people come before me and they say they were hanging out with the wrong people, AP2, who's listening here, the person who was the passenger who was too drunk to ride, guess what? If they were before me charging with the DWI, you know what they tell me? Judge, I was hanging out with the wrong people. And I would say, well, who are the wrong people? And they would say, you are the wrong people. So how old are you?
I'm 25.
All right, so you're old enough to know better. So it's not you hanging out with the wrong people. You have an alcohol problem. And you can't stop drinking. And yes.
That just like ever since I got out, you know, I've been sober for 7 months already. So, you know, I'm not looking back no more.
No, I mean, I appreciate the fact that you're sober, but when you think about it, you had a DWI from 2021 and then another DWI in 2024 of April, and now you're back with another DWI in November 2024. So I'm trying to figure out what you need to maintain your sobriety, because spending the 40 days in jail, you know, that's usually, I never want to see that again. I never want that to happen again. But obviously you've been in jail before because you have 3 DWIs.
But you know, I have family, you know, do it. I don't do it just for myself, you know. I need to be, you know, out and do right, you know. And that's what I'm going for. You know?
And who is this family?
It's my girl and my stepson and my brother and my dad as well. So,
All right. So in 2021, was your girlfriend in your life?
No.
Was she in your life in 2024 when you had DWI second?
No.
So just since this time?
In this time, you know, I'm trying to change and trying to do right. You know, I don't want to go back, you know, and that's what I'm aiming for success. And I think I could be a great member to the society.
All right. And how did you get here today?
I got dropped off, brother.
All right. I'm not going to allow him to drive until further notice. He needs to prove to me that he can make the appropriate decisions to be able to even have an occupational license, because your license is going to be suspended. And also that you can be trusted to make the correct decisions. All right. The court is going to sentence you to 10 years in the prison, suspended and probated for 8 years. This is run concurrent with 724620. There's to be regular reporting by Zoom or in person, regular random UAs, 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's to be 2-year license suspension. There's to be no driving until further notice. Do you have a vehicle?
No.
All right. Who do you stay with?
I stay with my girl.
Does she have a vehicle?
No, she doesn't.
So there's no vehicle at your home?
No, I tell my brother to pick me up and drop me off. It's mine.
All right. There's going to be a portable alcohol monitoring device with affidavit of non-driving. There's going to be field visits 1 time per month until further notice. Does anybody want to address the elephant in the room, that is the 60 days in the Bexar County Jail as a condition that's being requested by the state?
Well, Judge, as I already told the court, he spent 4 months in jail already before he made bond on this case. We would ask the court to take that into consideration if the court assesses the 60 days to give him credit for time served.
All right. These are your choices. This is your only choice with regards to the 60 days. You can spend 10 days on GPS, full house arrest. Or if you need to work, then you can spend 30 days on GPS partial for work.
Do the, I gotta work, I can do 30 days.
All right, so we'll do 30 days GPS partial for employment only.
Oh, I have a question. For outpatient, would they let me go? Cause I gotta go out.
They will.
Okay.
Can the court waive his fee, Judge?
I mean, I'll put it in there, but in order to do the waiver probation with the waiving fees of GPS, does that have to be through the jail?
Yes.
So he'll have to go pick it up at the jail. All right, so just so the record is clear, GPS partial for employment and treatment. Waive GPS fees. Are you doing any sober support meetings?
No,
All right. There's going to be 90 sober support meetings in 90 days.
and I had another question, Judge. I gotta show up to my probation as well. They'll let me do that as well.
Yeah, they will. And Ms. Abrams, I'm going to do a referral to felony drug court. I just want you to know what the program is about. I think it would be beneficial for you if they accept you. It's a very difficult program, but you're going to need a lot of help to successfully complete this probation and to get a little bit of a control on your addictions and not start making the right choices as to drinking. You understand? So if they accept you, then you should probably do it. But I'm not going to order you to do it because I know you have a lot on your plate, but that would be very beneficial for you. Probation, is there anything else? Thank you. Proof of employment within 40 days, no employment as a home health care provider or with minors. Anything else?
No, Judge.
All right, is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. To be successful on probation here, communication is key. If there's an issue, let your probation officer know about it. If you feel that they're not addressing it, you can always come back to the court and address it with me. Do you understand?
Yes, ma'am.
And the other thing, you say you want to be in your girlfriend's life, you want to be a good stepfather. Everything you do from here on out, you should have the tools you need. For example, if you think you're going to drink, pick up the phone, call your sponsor. If you're going to drink, think you're going to drink, pick up the phone, call your probation officer. You understand? Because from here on out, everything that you do, you need to be asking yourself, could this result in me potentially going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. You understand? All right, good luck to you. Who's here on Silguero? Santos? Yes. Okay. Court is calling 2025 CR 005704, State versus Santos Silguero. Could I have parties announced?
Moving gallery for state.
And Ron Ross for defendant.
And are you Mr. Silguero?
Yes, ma'am.
Counsel, have you received all discovery?
I have, Judge.
And did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Silguero, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it? Counsel, do you waive the reading of the indictment?
Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it? Did you understand you're charged with unauthorized use of a vehicle as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you are giving up those rights? Did you intend to give up those rights and enter into a plea in this case? All right, no gum chewing. Oh, don't swallow it. They say that messes up your intestines. That's what always was our fear as children. All right. Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Seguero, has anyone threatened you, coerced you, or placed you in fear to get you into this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,000 fine. State recommends deferred adjudication. They're taking in consideration 2024 PF 19499, and there's to be restitution payable to the complainant. Did you understand that to be the plea? Defense?
It is, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with the complainant, the MRT, no possession of firearms, and the job readiness course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offer states one an attachment.
No objections, Judge.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
You are, Judge.
Anything you wish to say on behalf of your client?
I do, Judge. Santos was 17 at the time of the offense, he's now 18. Just before that, his mother and father broke up and his family moved to New Mexico, Clovis, New Mexico. And he was kind of struggling at that time. His whole family moved there. He unknowingly, I guess, he spending some time in New Mexico. I said, did you get permission? He did from the bondsman. I said, from the court, no, you're supposed to have permission. But he obtained a job when he was there working in a cheese factory. And so, he doesn't have any priors. I don't know what this offense, I think the police report noted when they approached him, he was just kind of stunned and dazed. I don't know if he's got some problems. But he tells me one time he was at this court. I think I wasn't here or came late. In the hallway, he had a seizure and they had to take him to the hospital. So I don't know how that affects anything, but I would ask the court to consider his youthfulness, first time offense, and give him deferred and allow him to transfer to New Mexico if the probation would do that. So he can be near his family, he can have a supportive family.
All right, so why did you do this?
I really don't have no excuse. My mother and father had just divorced and my father had got locked up in prison and I really didn't have no one to look up to. I just got mixed up with the wrong crowd. I know it's not an excuse, but
No, it's not.
I just didn't understand. I was just in a bad spot. And no one to lean on.
Well, see, here's the thing about all of this. Number one, so hanging around with the only with bad people, you're the only person in the vehicle. That's not yours. And then the officers ask you to pull over. I've seen other people end up being shot and killed. They just tased you, and they had to tase you more than once. And then you still took off in the vehicle after they had tased you. Because I was wondering from reviewing the police report, I said, why is there an EKG in this police report? It is just an unauthorized use. It's an EKG for you. So you're going to have to turn your life around. Otherwise, you're going to find yourself at the prison or somewhere else. You understand?
Yes, ma'am.
So what county are you in New Mexico?
Curry County.
Sorry?
Curry County.
Is that Kerry?
CUR.
Oh, Curry. Okay.
It's Clovis, New Mexico.
And who are you staying with while you're here?
My grandma. Oh, here?
Yes.
I have no one here.
Well, I mean,
Who are you staying with though?
I'm here with my grandmother right now.
okay. And the reason why I asked that question is because I will grant your request to transfer, but probation will tell you you're not allowed to go there until you've actually been granted permission from probation to do so, because there are different legal standards that need to be met in order for you to be transferred, and the state has to accept that transfer. You understand?
Mm-hmm.
How far did you go in school?
I graduated high school.
All right. So what are you planning on doing with the rest of your life?
Get in a position where I could own my own business and don't have to work anymore.
All right. So what does that mean? What type of business do you want to own?
My father had already owned a bounty house business. I was thinking about just taking that over.
So you're going to be a bounty hunter?
No, bounty house entertainment.
Oh, bounty house entertainment. Okay. I was like, bounty hunter. What? Okay. So what are you doing to make that happen?
I'm working right now.
But what are you doing towards reaching that goal?
I'm working. I move with my family. I move with the right crowd. I'm not around anyone that I was when I made those mistakes or anything like that. I'm not doing any of that nonsense anymore.
All right. So this is what I mean when I say, what are you doing? For example, if I want to become a court reporter and somebody said, oh, that's your dream. Great dream. What are you doing towards that? And I would say, well, I've gone to courts and I've talked to court reporters, Cindy. And Cindy has said, hey, Stephanie, if you really want to be a court reporter, you got to go to school. And it may be, I can't afford it. So I say, I'm at my job. I found out that it takes, let's just say hypothetically, it takes $10,000 to go to court reporting school. So I'm working double shifts and I've decided that I'm going to set aside $200 out of my paycheck every time so that this is how long it will take me to pay my money to go to court reporting school. So it's great to have hopes and dreams, but you have got to start writing down, this is my goal. And you say your goal is to own an entertainment business, then you need to come up with a business plan. Like, okay, is this going to be brick and mortar? Where am I going to have it? How much is it going to cost? How I'm going to attract business to me? And when I say the entertainment, what does that mean? Am I booking DJs and getting gigs for them? Those are all things that you need to figure out. Otherwise, you're just doing dreams and they're not going anywhere. And when you look up, half of your life is going to be gone and you're going to be talking to somebody under the shade tree where they used to do shade tree mechanics. And you're going to be telling them about, hey, I always wanted to do this. You understand? All right, this is what the court is going to do. There's $1,000 fine that will be probated. 4 years deferred adjudication. Take in consideration 2024 PF 19499. A transfer to Kerry County in New Mexico. Regular reporting by Zoom or in person. Regular random UAs. If you're drug tested today, what are the results going to be?
Maybe marijuana.
See, you got to get your life together. Using marijuana is not, hey, I'm hanging out with the wrong crowds. That's all 100% you. So make sure on the regular random UAs, he's tested for levels. Proof of employment within 40 days, no employment as a home health care provider or with minors. Field visits 1 time per month for 6 months. There's to be no contact with and restitution to Saulo, SAULO, Lastra, LASTRA, 200 hours of community service restitution. 50 hours will be waived upon completion of the MRT. And the remaining 150 hours will be waived if you obtain some type of trade school certification or higher level of education. Probation, is there anything else? Yeah, within 40 days. No problem. Is there anything else you need for the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. So with the community service hours, I'm trying to help you out, right? That 150 hours, you can either go work and bake in the sun, make sure you have your sunscreen because it's going to get hot in Mexico as it is in San Antonio, or either you can do something to benefit yourself by coming up with a business plan and actually working that plan and trying to get any licenses that you need. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Larson?
Well, I mean, you want to talk to the deputies why that is case? Deputy Laura, he wants to know why his client is in 2 sets of chains.
Jail never ceases to amaze you.
The wonders never cease. That's what happens. All right, court is calling 2025 CR 0060588A, State versus Dorian Camarillo. Could I have parties announced?
Megan Galloway for the state.
Cornelius Cox for the defendant.
And are you Mr. Camarillo?
Yes, ma'am.
All right, so this is actually set on the docket for July 24th. But your attorney is here and you're asking for bond reduction, correct?
That's correct.
All right, and the court will note for the record, you are actually due to be here on June 9th, but jail transportation, the bus was inoperable. So that's why you were not brought here on that date. So you are here for this date. And to the clerks, did double check. I've already signed investigation motion, but I have another one. So if you could just check to see if you all have it or I need to sign another one.
Yes.
All right, State, are you ready to proceed on the motion?
Yes, sir.
All right, Mr. Cox, you may proceed.
All right, Judge, I called. I had the court to take judicial notice that the bond in this case is set at $500,000.
Okay.
Deported. And I call Erica Murillo. Please. Maria, my Espanol number Wayne. So learns.
Hey, I'm with you. Hello.
How are you?
Oh, I'm doing okay. Could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up because the court reporter has to hear. Off the record from Cindy, do you want to give her one of those little microphones that may help you? Oh, here, you can take this one. Oh, yeah.
No. You could just step up closer to the mic also.
Yeah. Here we go. All right. All right, if you'll state your name for the record.
Yes, ma'am. It's Erica Murillo.
All right, defense, you may proceed.
Thanks. And ma'am, Dorian Camarillo.
Camarillo.
Okay. Do you see him in the courtroom? Is he in the courtroom with us? Your son?
Yes.
Okay. All right. In your relationship, you're his mom, right?
Yes.
Okay. In terms of, do you live in San Antonio?
Yes,
Okay, and how long have you lived in San Antonio?
going to 3 years now.
And presently, you live in a house or apartment?
When we used to live in Dallas, a house,
Okay, but here you live in an apartment now or?
A house.
A house, okay. And who lives in that, who normally live in that house with you?
my son, my daughter, and myself, and my
Okay,
pets.
now. In terms of your son Dorian, how old is he?
Dorian, he's 17.
17 years old?
Yeah,
Is he a high school student?
yes,
What school does he live?
Reagan High School.
And
All right, just one second, off the record. Now, he's already on it, been appointed, okay. Sorry, Mr. Cox, we were just cleaning up the matter. Mr. Cox, you may continue.
all right, thank you. Okay, and your son is you indicated he's in high school, correct?
Correct.
And is a Reagan High School?
Yes, sir.
And that high school is in San Antonio.
Correct.
And what grade is he?
11.
Second grade. So you anticipate that he will be graduating high school next year?
2026.
Now, are you employed here in the city?
Yes, sir.
How are you employed?
FedEx. Well,
Now, ma'am, you understand that your son filed said at $500,000.
yes, sir.
That's something that you could. With his bond set at $500,000, can you bond it?
We have family things that can help us. Yeah.
But you can't. Can you make the $500,000?
No, 500,000. Maybe a little bit lower. That works for us. Yeah.
Now, your son presently, is he presently employed?
He was, whenever the summer school, that's when he used to work.
Basically, he's a full-time student, correct?
Yes, only on summer he used to do it.
Does he have money in the bank?
No, no,
Does he own any property?
no,
So he basically, in terms of the house where he lives with you.
yes,
And you provide his basic.
correct.
And you support not only him, but his sister also.
My daughter, yeah.
Okay.
I have a daughter also. And my pets.
Okay. Pat with you.
All right, State.
Ms. Murillo, you said you currently live in San Antonio, is that correct? Okay, and you said you've lived here for about 3 years, is that correct?
Yes,
And you lived in Dallas before that?
20 years.
Okay, do you still have family in Dallas?
Yes.
Okay, what does that consist of up in Dallas?
That's family.
Dorian's
dad.
That's Dorian's dad, that's.
The family.
Okay, and he has family up there as well?
Mm-hmm.
Okay, and did Dorian attend school up in Dallas?
Yes. Mm-hmm.
Okay, up to what grade did he go to school up there?
We moved from Dallas to Virginia when he was 11.
Okay, and so he attended school from the time he was 11 until 3 years ago in Dallas?
No, he was born in Dallas, my son. So he went to pre-K all the way when he was 11. So then we moved to Virginia for like 3 years. And he attended school over there.
Okay.
And then we moved back to San Antonio.
Okay, so let me see if I'm following you correctly. So Dorian, your son, he was born in Dallas, is that correct?
Yeah.
And so you lived there with his father in Dallas when he was born?
Yeah.
Okay, and then you lived there for some time until Dorian was 11, is that
11.
correct? Okay, and then at that time you moved to Virginia. Okay, and so do you have family in Virginia as well?
No, that's because of daddy's job. We do a construction environment.
Okay, okay, and so did Dorian attend school in Virginia as well?
Yes.
Okay, so it's fair to say he probably has friends still in Dallas and probably in Virginia.
More in Dallas.
More in Dallas?
Yeah.
Okay. And then you all moved to San Antonio 3 years ago.
Yes.
Okay.
Yes.
And so you said that you live in a home currently, is that correct?
Yes, ma'am.
Are you renting that home or do you own it?
No, we rent.
Okay. And your daughter that you also have to support, how old is she?
My daughter Sabrina, she's 15.
Okay. And so she's not working, is that correct?
No.
Now you said that you work at FedEx, is that correct? Is that full-time or part-time?
Kind of like part-time.
Okay.
Yeah.
What are your working hours?
From 3 a.m. to 9:30 a.m.
Okay. And what is your hourly rate that you get paid?
$20.
$20 an hour.
Mhm.
Do you get any extra compensation for working like a differential shift overnight?
No.
No? Okay. And how many hours per week do you work?
25.
25.
27 sometimes.
Okay, at $20 per hour.
Mhm.
So you stated that have you contacted any bonding companies yet?
Yes,
Okay, about how many have you contacted?
like 2 of them.
Two, okay. And you stated that you've kind of started to gather family to help you?
Yes.
Okay, and so that's a resource that you have, your family is willing to help you to make the bond, is that
Yes,
correct?
ma'am. That's correct.
Okay, and you stated Dorian in the summers that he used to be employed, where he used to work at?
With Daddy.
Oh, in the construction,
Mhm.
okay. And so, do you have a car?
Yes, ma'am.
Okay, and you own that car?
No, I'm paying it off.
Okay. We have to listen, sir.
Any further questions? All right, thank you. I'll leave with the court reporter.
Yes, ma'am. Thank you so much.
You're welcome.
We rest.
All right, state you can have a seat. State any witnesses?
Witnesses, Judge, but at this time we offer State's Exhibit number 1 for the purposes of this hearing.
Any objections?
Objection, Judge, that is not evidence. They're proffering. I presented evidence. So that proper. And this is not evidence. So I would object to it. That's grounds.
All right.
Proper cause hearing, I think sometimes you can use hearsay, those type of things, but for evidentiary hearing.
But also for bond reductions, correct?
Yeah.
Because the rules of evidence don't apply to bond reductions. Am I incorrect?
I think for someone, my position that is that someone would have to be the person that they would present the evidence. Just by, I can put in a encyclopedia and say, well, just look at this. Someone would need to be able to make the correct profit. I don't make the correct profit.
Okay. All right, the objection will be overruled and the court will review State's Exhibit number 1 just for purposes of this hearing. And if y'all will step back while I read this. All right, Mr. Camarillo. All right, the court has read State's Exhibit number 1. And Mr. Camarillo, the court is reading State's Exhibit number 1 really for the sole purpose of making a determination on what your bond should be set at. That will ensure the safety of the community and also ensure that you appear at court.
Yes, Your Honor.
That's what this entire hearing about. The State's Exhibit number 1 is not for me to review it in light of, does the state prove its case beyond a reasonable doubt? Because that's something where witnesses will be called and your attorney can make objections and you may have hearsay objections and other type of objections. So this is strictly for me to review that, take in consideration the testimony of your mother and decide what your bond should be set at. Do you understand?
Yes, ma'am.
So I've reviewed the documents, I've heard the testimony, and the court will hear argument on bond requests.
Since it's my motion that I waive opening and reserve to closing.
It's so rare that defense attorneys get a chance to do that. When I see it, I like to see it. All right, State.
Judge, at this time, we're requesting that you keep the bond at $500,000. I think what came out during the testimony, well, in addition to State's Exhibit number 1 and community safety aspect of this offense. In addition to, and what came out in the testimony is that the defendant does not really have sufficient ties here to the community in Bear County. I believe that he's a flight risk based on the testimony that he has sufficient ties, mostly in Dallas, but also avenues in Virginia. Further, the testimony is that they have began reaching out to bond companies and have additional members of the family to help make the bond. And so we believe that is set in a sufficient amount and would request that you keep it at 500,000.
All right, and Mr. Cox, if you don't mind, if I could take up Miss Russell's case, only because she has to travel to take care of another client.
That's fine.
All right, a CPS client. So if you'll just have a seat, if I could see the parties on Christina Garza. Yeah. Court is calling 2025 CR 003866 State versus Christina Garza. Could I have parties announced?
Megan Galloway for the state.
Elizabeth Russell for Christina Garza.
And are you Christina Garza?
Yeah.
Counsel, have you received all discovery? Did you review it with your client?
We have, Judge.
Court will find that the state is in compliance with discovery. Ms. Garza, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are waiving the repeater enhancement.
Any objection?
No objection from defense.
All right, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4,200 grams, that's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am. Sorry. I distracted her, Judge.
That's okay. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Judge.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Ms. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine and state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 6 years. There be 200 hours of community service restitution, TAP evaluation, no contact with Miller Park or 2802 MLK Drive, and the moral recognition therapy course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
State offer states 1 in attachment.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge, we waive PSI.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client has been a drug addict since she was 15. She hit a rock bottom, and we've submitted evidence to you that she voluntarily submitted herself to drug treatment. She's submitted a hair follicle test as of May 2025. And if you tested her today, she would test absolutely clean for absolutely everything. That includes marijuana, that includes THC, that includes CBD. She is rebuilding her life. And she believes that she will be successful on probation because of the commitments that she has made to both herself and to her family. And she really has already seen the success of making those life changes. She is in a part-time program through which college? I'm sorry. SNHU for substance abuse counseling. And she has a full-time job, and she is on a road to reunification with her child. She fully believes that she'll be successful on probation because of the choices that she made voluntarily, and has seen your rulings in the court and the conditions that you've required of people, and know that she can be successful in this.
All right.
And we actually submitted to you with.
I have those, yes. All right, so how old is your child?
She's gonna be 6 on the 27th.
Okay. So are you having visitation with her through CPS, or what's going on with that?
With Mary Contreras, I'm sorry, Judge. With Mary Contreras through Blue House, they're doing reunification therapy. She has not been in her child's life since she was 6 months, mostly due to the substance abuse. Because she has been able to provide those steps and that progress, that reunification therapy has started. She has one scheduled for today that she would really like to make. And she has shown that progress to the courts, and I think that is why they're giving her that opportunity.
All right. And so who has the child been living with prior to this?
Her father's mother.
Okay. All right. So here's the thing about that. And I'm glad they're doing reunification therapy with you, because sometimes people want to come in and they want to act like they've been there forever. And you can't do that. You got to meet her where she is in her growth and where you are in your growth. Okay. All right. This is what the court is going to do. There's a $2,000 fine that will be probated. 4 years deferred adjudication. Proof of employment within 30 days. No employment as a home health care provider or with minors. There is to be 200 hours of community service restitution. I'm going to order parenting classes. If you provide proof that you've completed it within this year, then the court will count that as your parenting classes. You understand? So how far did you go in school?
I got my GED.
All right. So what is your goal in life?
I have a full-time job.
All right. Doing
We'll
what?
address that in a second. We'll address that. I know you're freaking out.
Yeah.
We'll address it in just a second.
So what do you want to do with what is the big picture? What is your dream job?
I want to be a substance abuse counselor. That's
all
what
right.
I'm going for.
So the court will deduct 100 hours from the community service restitution once you provide proof of completion of parenting classes. The remaining 100 hours will be deducted if you obtain some type of trade school certificate or certification in your field of choice. There's to be no contact with, have you had any contact with Elizabeth Rios?
No.
All right, so there's to be no contact with Elizabeth Rios or Miller Park or 2802 MLK Drive. There's to be regular reporting by Zoom or in person, regular random UAs, field visits 1 time per month for 6 months. Probation, is there anything else? All right, is there anything else you need from the court in order to be successful?
Yes, Judge. And so she does work as a home health care provider. She has worked hard to get this job. I understand she's worked hard to get this job, and a part of her ability to be successful and her sobriety has been the ability to provide for herself and hopefully pay for this reunification. With permission of her patients, will the court allow her to continue working?
I will consider it, but you have to get a letter from whoever you're caring for. And that letter has to let them know specifically what you're charged with, what you're on probation for. I'm not saying I'll do it, but I'll consider it. And I'm definitely not going to do it if the state is not in agreement with them. Because one of the things, my job is to protect the community, and being around vulnerable persons when you have felonies, that's tough for me. So usually no employment with children or home health care providers. You understand? So for us to even get too close where I would consider it, there needs to be a letter from the employer that you work for who's sending you out, and also a letter from the people that you're providing care for.
And we have provided the letter from the employer. We will provide the specific letters from the patients that she cares for. Is the state in agreement if she has those letters?
Well, I would have to review them first.
Okay.
All right. Anything else?
We'll do our part.
All right. Is there anything else you need from the court? All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? All right. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right. So here's the thing. In this court, communication is key. To be successful, you need to stay in contact with probation. If there's an issue, let probation officer know about it. If you feel they're not addressing it, you can come to me. If you ever think that you're about to use, pick up the phone, call your probation officer. They're going to try to get you help. What I can tell you in this court, if people use, all you have to do is pick up probation and say, hey, I think I'm going to use. They're not going to file a motion to revoke. You know what they're going to do? They're going to come to me with the compliance hearing saying, hey, this person thinks they're about to use. What can we do to help them? You understand? But if you don't call them, there's nothing we can do. All right. Good luck to you.
Judge, I did have one additional thing.
Sure.
He resides in Abilene. And so we would request permission for her probation to be transferred to Abilene.
All right. And what county is that? I'm sorry?
Taylor.
All right. And then we can do transfer to Taylor County. No problem. And Abilene. All right. Thank you.
Thank you, Judge.
All right, Mr. Cox. Thank you, Mr. Cox. She said that she had someone who had a child reunification meeting, so.
No problem.
All right, so we're back on the record in 2025 CR 00605-8A, State versus Dorian Camarillo. The parties re-announced.
Megan Galloway for the state.
Cornelius Scott for the defendant.
All right, and so we were proceeding with closing arguments, and the defense had reserved their
Yes.
closing. You may proceed, counsel.
Judge, one thing I noticed, most times when the state make their positions on bond, their goal, if the person has a prior record, that's one of the first things that we hear. Nothing, silent. Client doesn't have a prior record. Secondly, it appears that when the original bond was set in this case, the original charge was capital murder. That charge has been reduced. Because as everyone knows, capital murder would be, if you were convicted, it would be life without parole or possibly the death penalty. Not in his case because of his years. So we're not talking about those type of situations. We're actually talking about a first degree. So what I'm asking the court to do in this case is set the bond, which is typically set in a case where there's a first degree. Now, the state proper state exhibit number 1 in even in that proper, it doesn't suggest that my client shot anyone or urged anybody to do that. It appears that the person that is deceased was a person that was allegedly in a vehicle, and it never an indication that my client at all did anything in terms of physically to harm this person. It appears that the perhaps the victim in alleged aggravated robbery actually shot and killed a.
So this is one of those cases, I believe, where you have the alleged defendants in a vehicle and the complainant is alleged to have shot one of the people in the vehicles, but it's also alleged that it was in the process of persons in the vehicle committing an offense. That's one of those Texas rules. Murder, yes.
So you have to do a lot of twisting and turning and maneuvering in terms of understanding. So my position, Judge, is that if it's murder case, first degree, at this point, we just want the bond set where a first degree case would normally be set. And my position is that that is typically around the $100,000 mark, maybe up to $150,000 mark. I'm just asking the court we have a young man who's still in high school, to set it at somewhere in that area, even if the court needs the assurance of a electronic monitor, to have it monitored at all times. And that's fine, that's understandable. We just feel that to keep it, if the state reduces the charge, just with the court, the magistrate originally set it at $500,000 based on the allegations of a capital murder. And that case is reduced, then we just feel that the bond should be reduced to what is typical in a first degree situation. And that's all we're asking for, something that's in that.
Okay. All right. So what I can tell parties, and I want to make sure it's clear, because on what I have on the docket sheet, it says capital murder. So it's no longer listed as a capital murder. Is that correct?
That's correct.
That's the indictment. Felony murder and count 2 aggravated robbery.
Okay. All right. Anything else to put?
No.
And as a condition of his probation, as a condition of his bond, is one of his conditions already for GPS or no?
Well, the copy that I had it was a blank copy. So, but I would imagine that it would be GPS.
All right. Let me just.
Are you looking for it?
I'm trying to look up his conditions of bond. It's not in my system. I don't have that in my Odyssey, at least what I have access to.
When I look at the notes on the jailing of the defendant, it says GPS full house arrest, no contact with the family and paid in full, no firearms, and random drug / alcohol test.
Okay. All right. This is what the court will do. All right. What I can say is, based upon what the court has read and State's Exhibit 1, number 1, and State, is it correct that this defendant does not have any prior cases? All right. So based upon what the court is reading in State's Exhibit number 1, based upon the evidence that has been tendered, in just one moment. All right, this is what the court is going to do. Court is going to set the bond at $250,000 with all previous conditions to include full GPS. There should be no contact with Roberto Alejandro Monreal, Esteban Torres, the family of Hayden Holt, Dorian, I'm sorry, there is another person. What is Harris's name?
Joseph.
And also Joseph Harris. All right, any other conditions you would like added, state, or are you requesting?
Judge, if I could just see the status of
Yes.
Judge, in the conditions that you had Eric, is that correct?
No, I did not put down Eric. You say Eric?
Yeah.
And that's Cepeda with the S?
Yes.
All right, and no contact with Eric Cepeda.
And then one other person, there's Janelle, I know his last name. If I could just have something.
Sure. And Norma, can you give Mr. Camarillo a reset form in case he makes bond? And it should be for July 24th. Roberto Monreal, Esteban Torres, Joseph Harris, and the family of Hayden Holt.
I believe that's all you're.
All right, anything else?
I have a request
Yes,
for employment,
I'm sorry, what?
for employment.
No. I'm not going to allow you to have employment. You're going to be on full GPS. That means that you have a location and you cannot leave that location. If your family is going, we can go off the record, if your family is going to the Whataburger, or is it Whataburger? I don't know.
What, I think it's
Whataburger,
what-
or Burger King, or wherever they may be, or to HEB, you're not allowed to go. You are staying at whatever location that GPS is at. Do you understand?
Understand.
So if your GPS is for you to be at a specific residence, because you have to have a residence in order to have GPS, you cannot leave that residence. And the way those GPSs are now, they're very sensitive. So what does that mean? If your family is having a cookout in your backyard, you can't go to the backyard to get your plate. They'll have to bring it to you. You understand?
Yes, ma'am.
You can't go to the mailbox. It's going to go off. And if there's a violation of that GPS, what's going to end up happening? Somebody's going to review the violation report. They're probably going to issue a judge's warrant, and then we will discuss it later and evidence be presented. And if that evidence is enough to show that you violated your GPS, a judge may remand you without bond. Do you understand?
Understand.
All right. Anything else? Thank you.
Oh, with the waive fees on the people.
I'll ask that fees are, now that is an excellent question. I'll ask that fees are waived.
Oh, thank you.
And who is his client?
He's out here, Your Honor.
All right, Mr. Willard.
How do you know, Your Honor?
I'm doing okay. How are you doing?
All
All right, your attorney is actually in another county. They had him scheduled for jury trial, but now he's not going to jury trial, and it would take him too long to get back here. So we're gonna bring you back on Thursday, okay? Do you have any questions?
Real quick, just a moment at a time.
Sure. But before you, I'm gonna give you a moment of my time, but before we go down this road, if it's something specifically about your case or the facts in your case, it's best that you discuss that with your attorney present.
It's more the fact of him himself and me hiring as a paid attorney. And what time do I have to do that?
Thursday.
By Thursday?
Okay.
Thank you.
All right. So Willers will be back on Thursday.
Yes, sir.
All right. Thank you.
Thank you, ma'am.
You're welcome. All right. Who else do we have in the box? You're Alan? All right, Mr. Allen, come down. All right, Mr. Allen, we are still waiting for your evaluation to be completed. I'm sending an email to the court to ask them to expedite it, okay? And then let me see what page is he on the docket, please?
What does that mean?
Oh, so there's somebody who's going to talk to you, and they need to talk to you because we can't proceed with your case.
Dustin, Derek, one of them talk to me?
Yeah, no, not It's going to be a doctor that comes.
Dustin or Derek.
Okay, they'll come and speak to you, okay? Yes, they will come speak to you.
Yeah, Jared Hoover, because that's who I usually industry work with, so I think it's an industry problem.
Okay. Well, we're gonna work on that because I want to make sure that you get a chance to speak to who you need to speak to so we can go forward with your case, okay?
Okay.
And I want you to be able to speak with your attorney so you can help the attorney with your case. So I'm gonna send an email and ask for them to expedite it, all right?
And do I get time served until then?
No, what will end up happening is your attorney will speak to you about that, but what I can tell you, the time that you're in jail, all of that counts towards your time, okay?
Full time. I didn't have a violation of probation. I did not have any gun or ammo when I arrested. I just didn't have that.
Okay.
So,
right.
what was my violation of probation?
Well, we're gonna see what we can do with that. Norma, when can Mr. McLean be here? Tell him he needs to be here on Thursday.
Because once seeing one in the Allen family, is there anything wrong with me seeing my family every once a week as well as doing?
Okay.
It was just like the last 2 or 3 days I've seen them every 2 or 3 days. They arrested me for some warrant that had no number, 71442W is what I found. And not when I was arrested, it was 2 or 3 different numbers ended with 2W. Very strange, very strange.
Okay. Well, we're gonna see if we can clear that up, okay?
Great.
All right, so we're gonna see you back on Thursday.
Okay.
All right, thank you. All right, anyone else? Is that everyone?
And Davis.
All right, could I see the file on Davis, please?
You want to excuse me?
Yes.
Thank you.
Good job.
Judge, that's the one that you reset to July 10th.
All right.
Reporter's fine.
All right, Mr. Davis, you'll be back on July 10th, okay? Yes, so it's coming back on the 10th. Your attorney just needs more time to look over everything. All right? Yes. So he's moving as quickly as he can, but he'll get it done, all right?